Welcome to the Florida Bar's presentation on the new electronic discovery rules. On July 7th, the Florida Supreme Court adopted civil procedure rules for the discovery of electronically stored information with an effective date of September 1st, 2012. This 3-credit course discusses the new rules and the context and framework in which the new rules were applied. Viewers of this program will probably have different levels of experience with electronic discovery. So with that in mind, we created a program that discusses the rules basically. In other words, we'll talk about what exactly is in the rules. Then we'll proceed to what the implications are in Florida practice of the various rules that were adopted. And then we may, in different rules, discuss some pretty sophisticated or advanced applications of the rules in Florida practice. We'll try to give you a heads up when we get to that portion of the program. To present this program, we've selected a panel of lawyers who are Ralph Losey. Ralph Losey has been a practicing attorney in Orlando, Florida since 1980, and he's an avid computer hobbyist since 1978. He was a partner at Ackerman Centerfit and a commercial litigator in Orlando for 26 years. In 2006, he limited his practice to e-discovery issues, and in 2010, he moved to Jackson Lewis, a 700-attorney firm with 49 offices around the country, where he now directs the firm's e-discovery nationwide. Ralph Losey is the author of 4 books on electronic discovery and a popular weekly blog entitled E-Discovery Team. Next, we have Bill Hamilton. Bill Hamilton is a partner with the law firm of Quarles & Brady and was a founding partner of the firm's Tampa office. Mr. Hamilton is board certified in business litigation and in intellectual property law by the Florida Bar. He is currently co-chair of Quarles & Brady's electronic discovery practice, where he is consulted regularly on electronic discovery matters and writes for Quarles & Brady's e-discovery blog, which is called E-Discovery Bites. Mr. Hamilton teaches electronic discovery and digital evidence as an adjunct professor at the University of Florida's Levin College of Law. I might also mention that Ralph Losey is an adjunct professor at University of Florida as well at the College of Law. The third panel member that I'm going to introduce to you is Kevin Johnson. Kevin Johnson is a shareholder in the firm of Thompson, Sizemore, Gonzalez & Hearing in Tampa, Florida. Kevin is board certified in labor and employment law by the Florida Bar. During his time on the Florida Bar's Civil Procedure Rules Committee, Kevin chaired the e-discovery subcommittee during the year that it completed the development of the e-discovery rules amendments that we're going to be talking about today. And as chair of the Rules Committee, he argued them before the Florida Supreme Court. So he has experience in practice with electronic discovery, and as well he was so the father, I guess, of electronic discovery rules in Florida, or at least a founding father anyway. The next person I'm going to introduce is myself. I'm Ralph Artigler. I was a board certified civil trial lawyer for 24 years before I went on the bench. What's pertinent to this discussion today, however, is that I've been teaching electronic discovery to judges and lawyers for over 10 years. This is an area of special interest for all of the panel members here. All of the panel members are very interested in education on electronic discovery and have participated together and individually in many electronic discovery programs. Bill Hamilton and I are co-authors of the LexisNexis Practice Guide, Florida E-Discovery and Evidence, which has been fully updated to the new rules and is available from the Florida Bar as well as from LexisNexis, because it's a bar publication as well as a LexisNexis publication. That e-discovery book would be updated not only to the new e-discovery rules, but it'll cover everything we're going to talk about today and then more, okay? And there will be a mention of other resources in addition to that book as we go along in the program. Now, we've provided you in advance with electronic handouts that you could print out. They contain a number of things: citations, glossary of terms, comparative charts, and so forth. I'm going to briefly discuss the handouts that will be helpful for you in today's presentation, so that if you hadn't prepared to have them with you, you can get them if you feel you want to have them with you. The first one is handout number 1. Handout 1 has the new e-discovery rules text compared with the prior text, and we will be referring to that handout by page and line number. Of course, if you've got a completely updated set of the civil rules, you can refer to the text of the rules in the rules themselves, but that handout should be a handy reference to you if you want to look at the rules as we're discussing them. Handout number 2 are the citations that we're going to discuss today. We have cases, ethics opinions, rules of professional responsibility, and then cases from the Supreme Court on various electronic and discovery matters. Those citations are available and would be helpful to you. There is some additional information on the citations, not just the citations themselves, if you want to have that available. Handout number 3 is a glossary of terms that some of which are technical, some of which are legal, that we're going to be discussing today. That glossary, there are glossaries available. There's a Sedona Conference glossary. We have a glossary in the e-discovery book that we showed to you. But this is a glossary of commonly used terms that we're going to have today, and it may help you to have that glossary available if you want to have it. Handout number 5 is the Bray and Gillespie saga, illustrating an e-discovery gamesmanship and resulting sanctions. That's going to be something we're going to talk about later, and that'll assist you in understanding what's going on in that discussion. And then the last handout that you might want to have with you is the EDRM diagram, the electronic discovery model illustrating the steps in the e-discovery process. That's just a one-page, and if you have that available during the course of this, it should assist you in seeing what's going on in that portion of the program. We will also identify during the program resources beyond the information that we've provided to you that will assist you in getting greater information than what we've presented to you today. So let's get started with our program, because we've got a lot of information to provide you. It's a 3-credit course, one of the hours of which also gives you ethics credit. So we're going to have basically 3 50-minute segments for you to watch on electronic discovery. Let's start out, Kevin, with telling us a little bit about the background and why the Florida e-discovery rules were adopted.
Thank you, Ralph. I think the first thing to understand is that this is something that came out of the Florida Bar Civil Procedure Rules Committee, and it was a response to really the background of the last 20 years, where we've seen just an explosion in the amount of documents that are stored electronically, the amount of different types of evidence that are out there that are electronic in nature, as opposed to just sitting around in paper on a file cabinet somewhere. What that has meant is that you're dealing with a different type of information. That information may be more easily duplicated. It might find its way into many different computers as opposed to sitting in that one file cabinet. It's somewhat less persistent. It can be easily changed by just hitting a delete button, or by making a routine command, or just allowing something to expire naturally. So in that context, when in addition to all that, you also have, in many cases, valuable metadata that is stored in those files and associated with it, it became clear that there were going to be more disputes, that this was critical to litigators to understand how that change in the type of information we deal with on a day-to-day basis needed to be dealt with in the court system. The Florida Bar Civil Procedure Rules Committee had a subcommittee that was appointed specifically to study this. And for several years, that subcommittee spent time studying the federal rules, which were adopted in 2006. And the committee tried to decide what were the highlights of those rules. Was it worthwhile to adopt them in roughly complete form, or were there changes that needed to be made to bring them into line with the federal rules? And at the end of that process, the subcommittee decided that for a number of reasons, the Florida rules should be closely modeled on the federal rules.
Well, why is that? What's the benefit of having a model closely to the federal rules?
There are several advantages. One of the things that I think is very important, what the subcommittee felt was important, is that you don't have to you don't miss out on the great amount of precedent that is already out there. There have been a number of cases decided under the federal rules, and instead of Florida having to reinvent those precedents and come up with them a second time, litigators can rely on those because the rules use essentially the same language in many places. So those precedents are still valuable. And I think the other thing is we've decided that it's important for Florida courts to make some modifications in those in a couple of areas that we'll talk about later in the program. In addition, you have the predictability advantage that if you're advising a client, you don't have to change your answer depending on a guess as to whether the federal rules will ultimately apply or whether the state rules would ultimately apply.
I know that in federal court, we have magistrate judges who handle most of the electronic discovery issues. And Ralph, were you pleased when the rules tracked the federal rules?
Yes, I was. I started working on this project in 2006, and I was always a strong advocate for following the federal rules as closely as we could. I wanted to have as little creativity as possible because I wanted our judges to have the benefit of the federal rules, which I believe were very well written. Thousands, tens of thousands of hours by the top scholars in the country went into creating the federal rules. We have thousands of hours that have now gone into our version of it. And I think, you know, I'm proud of what the Florida Bar has done in not exactly word for word copying, because we always have had slight divergences, but in following the federal tradition is going to open up a wealth of precedent from the federal magistrates around the country, whom, as you know, specialize in discovery. And really, there's some top experts out there all over the country that have written some very helpful opinions, including magistrates right here in Florida.
Well, one of the interesting things for me as a state court judge was that I didn't write opinions on discovery matters. So do you expect that Florida judges will be writing opinions, or do you think that a lot of what we turn to in precedent is going to come from the federal magistrates?
Well, I think you make a good point, Ralph, and we probably will still primarily have written opinions by the federal bench. Although I will tell you, I've already seen pre-rules written opinions on discovery by circuit court judges. So they are out there because they want to provide some guidance to their other judges. Problem is, a lot of the times, particularly before they were the rules, you were breaking new ground as a state court judge, and it was not uncommon, I'm told, for them to spend dozens or hundreds of hours into a project. So they would sometimes write an opinion, which is a little bit unusual for state court judges, and I think they will still do that. They're not as easy to get, but you can still get a hold of state court opinions. So I would predict that we will start seeing some state court opinions on discovery really for the first time. But it'll be nothing compared to the vast, you know, literally every day there's probably 10 or 20 different opinions published in the federal judiciary somewhere around the country having to do with e-discovery.
Well, do you think that the rules as they've been adopted will be a good blueprint for judges so that they might be on the right track when the state court judges jump in on one of these things?
I think they are a good blueprint for judges and for practitioners as well, and for everyone. And it gives us, you know, a solid body of law there that's already been well established. 6 years now it took for Florida to, you know, basically do what this federal level did years ago. But, you know, like I said, I'm very pleased with the result. We have restrained ourselves and not try to create a Florida-only version like California did that created a very unique kind of version. So I think we were smart to go into and adopt as much as possible the federal rules and the precedent rather than going the route that some of the other states like California have taken that have really reinvented the wheel, because that wasn't necessary here.
Okay. And the Florida rules are based, Kevin, on actually precedent that we had in Florida and other application of Florida rules. Is that correct?
Yes, that's correct. The subcommittee tried to take into account the existing precedents that we had out there in state court. There's law that we'll talk about later in the program, particularly with respect to things like proportionality, and we felt it was very important to bring that into these rules. And one of the things the rules do that's helpful is that if you were dealing with this topic in state court before the adoption of these rules, you had to go out and do a lot of discovery or research on your own to try to find these case law, these opinions out there. You had to try to incorporate the federal opinions, and you had to argue then to the judge that this is the way that this should come out under Florida law. And then the judge has to go back and retrace all of your steps. Now, as a litigator, you can point to the rules and say, Judge, here's exactly how it's supposed to happen. The Florida Supreme Court has adopted these rules. They do want you to track exactly what the federal courts have done in these cases, and that's built into the reasons for adoption. And I think the other thing that was done with the design of the rules, speaking from the perspective of someone who was leading that subcommittee, and what we tried to do was to make sure that we were having some balance in them. And I think the federal rules do a good job of that to start with. But we wanted to make sure that these rules, as we adopted them, did not unduly favor the requesting party or the producing party, that they didn't unduly favor plaintiffs versus defendants. We wanted them to be useful to judges so that they could look through the rules, find what they need in the way of guidance as to how to resolve these cases. And we felt that was very important. We also didn't want the cost of a case to overwhelm someone. We don't want e-discovery to be this hugely complicated problem area which people avoid because they find it's unhelpful or it just overruns and takes over the entire case. And the committee tried to be sensitive to that and come up with rules that would allow us to meet all of those different objectives.
Would the panel agree, and if you don't, tell me, that because it's based on precedent that we had before, the rules really don't mean a great change for lawyers as much as a clarity for them and an ease of the blueprint? Bill, you want to handle it?
Well, I agree with you to a degree, Ralph, but I think the sea change we're talking about is for the first time the Florida Supreme Court has said we want Florida lawyers to be talking about e-discovery. You've got to. It's the new form of information we're dealing with in its original form. So e-discovery becomes a critical part of the dialogue and a critical part of the skill set that attorneys must have. So although, we could have looked at e-discovery from the lens of the previous rules, what the new rules do is they make it explicit what might have been implicit before and bring to the surface what I think is known by everyone now, and that is that this is the kind of discovery that we have to do in the future and going forward. So I think the rules provide a tremendous service to the bar in that regard by providing explicit guidance on the kinds of issues and the dialogue that has to take place now in commercial litigation. I'd also like to commend the committee, and we were all involved in this process, so it's a little bit of self-congratulatory work here, although most of the credit goes to Kevin. What the committee didn't do was try and jump in and create some artificial barriers to discovery or artificial structures that would limit the cost of e-discovery. We all realize that e-discovery can be expensive if it's not managed properly, but that doesn't mean that we want to do things that are a black letter when it comes to e-discovery that create certain boundaries that can't be crossed, or create presumptions that really are unworkable, as we're seeing happen in a number of other courts around the nation. So what we have in Florida really is a wonderful opportunity for lawyers to understand electronic discovery, to negotiate appropriately, and to figure out how to do e-discovery that's in a manner appropriate for their particular cases.
Okay, well, let's jump in then, and as we go through these rules panel, if you see something that emphasizes the points that we've made about the value of these rules, let's go ahead and bring them up. But let's go first to Rule 1.280B3. 1.280B is the scope of discovery rule, and B3 says that a party may obtain discovery of electronically stored information in accordance with these rules. Now, that new rule is on page 8, left column of handout number 1, which is your e-discovery rules. First of all, what do we mean by electronically stored information? A party may obtain discovery of electronically stored information in accordance with the rules. What is electronically stored information?
Well, electronically stored information is best looked at from the perspective of the kinds of methods of creating information we have now. And those methods of creating information are primarily through computer and computer-related devices. Those devices operate essentially by very subtle and sophisticated complex wiring that is run by electronic impulses. A memory in a computer is not really remembering something the way necessarily a human brain remembers something. It's preserving electronic impulse in a particular location within the computer memory to be processed by the computer. So when we talk about electronically stored information, we're talking about how a computer maintains, stores, creates, and utilizes information, and that information is in electronic form. Essentially, they're stored electronic impulses within these very complicated devices. So that's what we mean by electronically stored information. The key thing, though, is that the definition isn't specific to the rules and is a little bit open-ended because, for example, as technology develops, we're going to see newer and different ways of storing digital information. For example, information stored on optical drives can be stored digitally. So, we've got lots of a future in front of us, but I think the concept as it was taken really focused on computer technology as it exists now with the storage of essentially electronic impulses off and on, plus or minus, however you want to describe it, which is really the underlying guts and what the information is that we're now exchanging, discovering, and handling in the litigation process.
So if we defined it in the rules, then that would be a limiting thing that we don't want in the rules.
I think so.
And is that what the federal courts did as well, Ralph?
Yes, we followed the federal precedent. This was debated at length in the federal committees. And there is no definition. You may wonder why there isn't, and it's for the exact reasons that Bill has mentioned, and that is we're defining this very broadly without specifics so that it will last for another 10 years, 20 years, perhaps longer. So it's not defined on purpose to be all-inclusive. I would point out the obvious, and that is we got a new acronym here, Electronically Stored Information, ESI. This is something that you will see now for the next years in your practice, lawyers and judges referring to ESI. So that's the new shorthand. You might want to be a takeaway from this. At least you'll know the new abbreviation is that we're talking about ESI, which most of the time in a lawyer's life is going to be computer files of one type or another.
Oh, it's kind of interesting because things will be stored in a lot of places. They may be in your car. They may be in your computer. They may be in a video camera somewhere. So a lot of things will be in different locations. And this is meant to be broad enough to cover all of those things. Is that correct?
It is. It is. There's nothing specific because of the rapidity of change of technology. So I think Florida did the smart thing not to define it. Some of our other states have actually specifically defined ESI. We think that's a mistake. So just know that, and this, by the way, isn't a change. I mean, ESI was discoverable before the rules. There's been several opinions on that. But as you mentioned, we're basically articulating established law. This is also in accord with Sedona Principle Number 1. If you haven't heard of Sedona, that's another thing that is you'll hear probably throughout our discussion today. That's one of the most important resources that you can have as an attorney. It's a kind of a think group of lawyers and judges and scholars, librarians even, information scientists, technology people, all got together at the end of the last century to start working on these problems of how the law is going to cope with this incredibly fast change in technology that we've all seen. And so the Sedona Conference creates that glossary you mentioned before of key terms. Urge you to take a look at the glossary and also to look at all of the free resources that are available online at the Sedona Conference. Obviously, I'm a little biased. I'm a member of that, but it's something you might want to look at and investigate the free resources. The main one of which that is cited many times, and this is there's a lot of federal judges involved with this, is called the Sedona Principles. And principle number 1 was basically what we have here in this rule, and that is making clear that electronically stored information is discoverable. It's now pretty well established in every state. I don't know of any opinions that have held to the contrary that it's not discoverable, but it was important to put it in the rules to make it plain, just like it was the first principle in the Sedona Conference, so that there's no doubt that we all understand that the primary form of writing that we have now, which is using computers to write, that everything that's generated by these computers, if it's relevant or could lead to discoverable information, it is going to be part of discovery and should be part of discovery.
Yeah, Ralph, I think your point you made earlier, too, about the multiple locations, and I think, Kevin, you mentioned that as well. We should think of this as information stored in computer-related devices. It's hard to imagine machines now that don't have computer parts, computer operating systems, and other stored information in them that may be relevant to litigation. For the most part, we're going to be talking about computer files and computers, desktop computers, servers, and the like, but let's not forget that we're also talking about all different kinds of computer devices, which are proliferating as we move into the 21st century. iPhones and other kinds of handheld devices are really, miniature computers with certain kinds of information storage. And while we're talking about resources, another excellent resource is the EDRM website, which is at www.edrm.net. The EDRM graphic, which has become one of the standards of the e-discovery industry, is contained, as Ralph Articler mentioned, in the handout materials. And the EDRM website provides a rich depth of explanation and resources with respect to each one of the phases of the EDRM model. So when you put the Sedona conference together with the EDRM materials, plus the case law that's now available in Florida thanks to the Rules Committee, we've got an abundantly rich source of information to draw upon for e-discovery education.
I'm going to add one thing. When you talk about a lot of different places where things are stored, there's also a rich amount of information on some devices. For example, the smartphone that you were talking about may not only contain information about telephone calls you had, it may have text messages, it may have emails on it, it may have where you were at a given time when you made a phone call. There's just so much information, and that's not limiting. There's more beyond that. Yes, Ralph?
Well, that reminds me of a recent war story, which I'll interlude just to show, well, you may have a rural practice, but do your clients have cell phones? Do you have an iPhone? There's a case very recently up near the border with Georgia involving a dispute between neighbors, and one of them complained that a large pile of horse manure was dumped on his property. And the other neighbor said, no, that's not on your property, that's on mine, and I have every right to put my horse manure wherever I want. Well, somebody got the idea, they had taken a picture of it, to see whether or not that picture may contain metadata that includes the GPS coordinates of exactly where that camera was. The setting was turned on the iPhone, and sure enough, there was the exact proof dispositive of the main little battle going on. Where was that horse manure? And yes, it was on the other guy's property, and I think maybe they knew it. And so you'd be amazed how ESI comes in handy in all kinds of disputes where you're trying to find out what happened.
I also learned that there are more cell phones in the world now than toothbrushes. So that says a couple of things, but the important thing for us is the proliferation of electronic evidence.
Well, actually, Ralph, on the toothbrush front, I just read in a year and a half there'll be more cell phones in the world than the population of the world.
Wow. Well, in getting back to the definition of electronically stored information, which is broad, in the glossary we've provided you two definitions, one from our book and one from the Sedona conference. And you can see they're different, but they're both open-ended. And so you'll want to look at this to just as a lesson of how open-ended discovery is. But I want to ask Kevin, why do we need a rule saying that ESI is discoverable?
Well, I think it's exactly what Bill and Ralph have mentioned. We need it for clarity. We wanted to make sure that all of the attorneys and all of the judges in our system know that electronically stored information is a perfectly viable source of evidence and discovery. We don't want there to be any dispute. We felt it was helpful to have it in there for the sake of clarity.
Okay. I guess one of the examples that would bring it to a practical level for you as practitioners, let's say you're involved in a case and the other side has emails, and you want all of the emails during a certain period of time that are relevant to a certain issue, and the other side gives you printed emails. And then you go in front of the judge, and there may be a reason that you need the electronic emails. This rule provides the authority for you to get the electronic emails. The paper is not going to be enough. Why would you want to have electronic emails, Bill?
Well, Ralph, for the exact reason that Ralph Lucy suggested, it may contain additional information that's relevant to the case. For example, there may be an issue about where the email originated, how it came into the particular email system, so that the header information showing the path over the internet stops might be relevant. More particularly, when you're doing discovery, it may be relevant what particular file this particular email was located in, which disappears when you print out the paper. For example, suppose the witness, sometimes we call them custodian, had put the email in a file that said dangerous documents. Wouldn't you want to know that that was the file that the information was kept in? Well, of course you would. That information is lost when the email may be printed. And it takes us really here to a larger issue. Maybe we should just spend a moment on that now, which is really what is the information that we're talking about. As you can see on the desk in front of us, we all have paper that's been printed out. But this paper really isn't the originally stored information, if you will. The original information of all this is in electronic format. It's the information that Ralph Lucy alluded to as files that are stored within a computer in bits and bytes of information. That's the original information that we're talking about figuring out and understanding how to exchange in a proper way that makes sense in any particular case. And it presents challenges, and that's what this is all about today, is talking about the challenges associated with that and how the rules can help us manage those challenges. Ralph, you've got some thoughts on that, don't you?
Well, I can share another war story again. This is back when I was with Ackerman. I think it was Jim Foster got a production of email, and it was 2005. He got a couple of boxes of paper printouts of the email and a couple more boxes of paper printouts of the attachments. And some poor paralegal, I forget who it was, had to try to figure out what attachments went with what email, because that's metadata. It tells you. That's one example of metadata. It tells you which attachment goes with which email. Now, we kind of suspect it was done that way to us on purpose, and this is something, kind of a dirty trick some of you may have seen happen to you. Hopefully none of you watching us actually have done that on purpose, but the rules address that now. And so back in 2005, there was really nothing that we could do except complain loud about it. But now, as we'll get into it, the rules require that the form be usable.
Well, let's. I want to sort of take a little digression here, because part of what we're doing today are ethical responsibilities, and we sort of dove in on electronic discovery and the implications of what electronically stored information are for purposes of discovery. But anybody who got the July 15th version of the Florida Bar News knows that the technological end of things is impacting all of our practice, not just electronic discovery. Electronic discovery is a piece of the puzzle, but the landscape has changed for the exchange of information in lawsuits in Florida. The Supreme Court started a couple of years ago developing rules, and they put them in the rules of judicial administration. And here's, I guess, one other point that we're going to have. In the past, at least when I started in practice, if you knew the rules of procedure, you were a trial lawyer, you could understand what was going on. Now the rules of judicial administration have as many, if not more, of some of the important procedural rules that you have, especially in this electronic area. But the Supreme Court started by telling us that private information and confidential information needs to be protected from going into the record. By the same token, when you keep something from the public in a lawsuit, you have to go through certain steps. So they set out a couple of rules in the rules of judicial administration that would take care of those particular aspects, when you could ask for something to be sealed, and also a rule on what not to put into a record. And they were protecting not only the party's information, but they were protecting everybody's information. Well, the point that relates to discovery, and for all lawyers, is that you have to know enough about technology to deal with issues of confidentiality for your client. That includes privilege. That includes confidential information that, such as trade secrets and private information. Now, the Supreme Court just this last month in June passed a couple of rules. One of them is the e-filing rule, which is going to make the records be so available to anybody in Nigeria. They'll be able to get a lot of information. Now, there will be some limitations that they're going to put on how people can access that information, but the concern that the Supreme Court had was putting information in that people could access. So they set up rules with regard to that, but now we have an e-filing rule, and by next year, lawyers will have to know how to e-file. In addition to that, there's an email service rule, and I read 4 solid pages of the Florida Bar News about the implications of e-filing and the email service rule. Well, the point for us with regard to metadata, and Ralph is going to tell us in a minute what metadata is, if you're sending something to another lawyer, you have to know what you're sending that other lawyer. And the rule may be different if it's a discovery item as opposed to a non-discovery item. But first, let's learn what metadata is. Ralph, you want to tell them what metadata is?
Okay. The standard definition, the quick answer is metadata is data about data. And this is something that librarians have known about actually for, 100 years. This is one of their terms that's getting incorporated into the law. It is nothing new. I'm going to give you some examples about metadata. First of all, there's 2 types of metadata when we speak of it in the law. There's system metadata, which is data that resides basically in the filing cabinet, which is the computer system itself. And then there's metadata inside each computer file, data about the information. So let me give you an example of system metadata that you may have been familiar with, you may have seen before. Have you ever seen one of these before, gentlemen?
A relic.
A relic. This is a card catalog from a library. This is filled with metadata. This is equivalent to system metadata. This will give you information by which you can find and look up the particular book that you are looking for. It will give you enough information so that you'll know where to go, walk around the library, and pull that actual book. This is exactly what system metadata, what it does. And I don't want to get too technical, but there's places in the computer itself where it stores information about where all of the computer files are located. It's the equivalent of this card catalog. So an example of system metadata is the actual computer file name itself. If you open up if you create a document and you call it CLE1, .doc. That actual file name, that computer file name, is not part of the computer file itself, interestingly enough. Most people think it is. It is instead recorded in the operating system, in the actual system metadata that keeps track of where that file is. And it then, when you go to open, you do a directory listing, you try and find that file, you are in effect consulting the system metadata, the card catalog. You see it listed there in your directory listing, or when you're opening it as a Word doc, you click on it. That is telling the computer basically this is where this file is located on the hard drive. Because on that hard drive, this is an example of a hard drive here, terabyte hard drive. You can get it down at Costco, get it for, what is it now, only $150. There's enough information on a terabyte hard drive to fill up the complete library of any courthouse or any library in any city in the state of Florida. Can exist on one person's laptop computer here. So in order to find the particular document, you have to use the system metadata. So nothing new here. This is the same thing that we've been dealing with in the paper world. It's just now gotten a lot more complicated, and it's gotten a lot more voluminous, such that even the world's largest library, which is the Library of the United States, the Library of Congress, largest library in the world, every Fortune 500 company has more information stored on its computers than does the Library of Congress on its shelves, and all of the written material and all the photographs, all the movies that the Library of Congress has. Your everyday Fortune 500 company has more information than that. It's kind of mind-boggling. So that's system metadata. But what is, I told you there's 2 kinds of metadata. The one where the operating system keeps track of everything, and the other is in the actual file itself. And again, nothing new here. This is a book, happens to be a book for law students to study to take the bar exam. And every book has metadata in it. One very common example is pages. A page number tells you where to find a particular bit of information. It's data about the data. Another information that, of course, you would want to know, and that is the actual title of the book and the table of contents, where the information, again, might be located. And you would not want to take a table of contents. If someone asked you to produce a book, you wouldn't take the table of contents, rip it out, throw it away, and not produce it to the other side. Now you've made it less usable. The information is still there, but now where's the, how are you going to find where it is? You've just gotten rid of that piece of metadata. It's not part of the contents itself. It's information about it. Every book usually will also have an index in the back of the book. This allows you to look at the word and go and find the page in the book where this word is used. Every computer file, most of them, will also have indexes. And before that example I told you about the box of emails and the box of attachments that happened to us, and we're going to talk about it some more in Bray and Gillespie. It appears to be a favorite trick of people discovering computers, is to strip out the index in a computer file and produce it to the other person. It's called a flat or a dead file when you do that. That means that the people cannot actually read and use the wonders of metadata in order to search and find where a particular word is located in a document. It could be a 100-page document. You want to know where the word Ralph is. You hit find Ralph. It'll go to every place in the document that it is. It does that by an index. Now, again, if you were going to be producing a book, you wouldn't take the index out, rip it up, and throw it away. That would be an outrage, right? You've changed the evidence. You've made it much harder to use. And yet this is what is happening all over the place, all over the country, including our great state, where people are stripping metadata out of computer files, making them less usable. They may be taking actually the name of the file, the actual cover, ripping it up, and not producing it and saying, here it is, we've technically complied. This is what the Bray and Gillespie case is about. We'll get into later. This is something that the rules have addressed, that you cannot downgrade your information, that's what we call it, by stripping out key metadata. It has to be either in its original form or it has to be reasonably usable. And many courts in the system we found is that it is not acceptable to do, unless the other side agrees, to rip out the index, to rip out the table of contents, to throw away your card catalog. You have to keep that metadata together with the file, at least enough of it so that it's reasonably usable. So this metadata is not anything new, I would submit. It's something you've been using your whole life. You just didn't know that that's what the term was. And that's what one of the things the rules is designed to produce is more compliance where people do not do this kind of ripping off of metadata from files.
Yeah, that's very helpful, Ralph. And I think instead of thinking about metadata as something that's added to a file, a better perception of it is that it's information that's stored in the computer, either with the applications or with the computer operating system or otherwise, that the computer creates in terms of managing itself, just the way, as Ralph was pointing out, a librarian manages and keeps track of what's happening in the library. There's all kinds of files and information that a computer maintains that can be very important for litigation. So when you're dealing with electronically stored information, you're dealing with devices. So for example, a computer will typically keep track of the websites that have been recently visited by the person who's using the computer. That information is stored in the computer in a section called cache. What that is, and that's C-A-C-H, not C-A-S-H, what that is basically the computer wants to operate quickly. So what it does is it takes files or documents and puts them in an accessible place. Just so, for example, if you return a book to the library, instead of taking it back to the shelf, if it's a book that's used frequently, the librarian might keep it handy right behind the counter. That's equivalent to cache, but that information is stored in the computer as well. So what we're talking about is learning and having a comprehension of the kinds of information that's created within a computer that helps it manage itself. Another example would be when I put a thumb drive into my laptop, my computer is keeping track in its logs of every external device that's accessed by the operating system. That information can be very relevant in trade secrets and in a multitude of other cases. So what we have here is a vast amount of information, of which sometimes frequently the paper is just the shallow tip of the iceberg. But think of the device as having lots of information in it and having a dialogue about what information in the device or devices that you need in order to make your case.
Now, let's take a practical example of metadata so that we understand that it can be complicated in the application, not just in what it is, okay? And let's not worry too much about technically understanding how metadata is created, because the first time you learn that, when you go to a different software, it's created differently, because different software has different metadata and so forth. The important thing for lawyers to know is that the ethical requirements in Florida require a sending lawyer to understand what they're sending to the other side. Now, there are two sides to this coin. In discovery, if metadata is relevant and requested, it's improper, as Ralph has suggested, to strip that from the document. So if you strip the metadata, that can be spoliation, or if it's not recoverable, or it can be something that would cause you to have to go before the judge and then reproduce again in a format that's proper. However, when you routinely communicate with a lawyer on the other side outside of discovery, if you send the metadata to the other attorney, you may be sending more than you should send. And let me give you an example. Let's say informally, I have a case with you, and you've asked for my expert report. And so I ask my expert to send me the report. I get it in a word processing format. The common one that's used in the court system is Word, which is Microsoft Word. And I take this Microsoft Word document my expert sent me, and I'm diligent. I shoot it out to you in Word format. If I send it to you in Word, you've got far more information than you were asking me for. You were asking me for the content of that report, and I gave you a document that has when it was created, who created it, what changes were made, when the changes were made, all kinds of information. Now, how can that hurt me? Well, let's say that the expert changed their opinion from something that was favorable to your side and changed it to something favorable to my side. And then you find out in deposition that change occurred at the time that right after that the expert spoke to me on a telephone conversation. So you've gotten information that you didn't need. The important thing under your ethical obligations is to know what you send. So in one sense, it may be a problem for you to send metadata. Another time, it may be a problem for you to take the metadata off. What you have to understand is that there is metadata, and you have to know what you're sending. And for example, the new email rules require you to send attachments in a PDF format, which all of these terms are in your glossary, including metadata, system metadata, and so forth. But the PDF format is like a picture of a document, and it can have additional information attached to it, but for most part, you're safe in sending a PDF document and not sending things that you don't intend to send. But if you send a PDF in discovery, if you took a Word document and created a PDF out of it, it might be a problem for discovery. Bill?
Very likely would be a problem in discovery. It's what Ralph Lucy indicated would be called data downgrading. Under the rules they've been propounded, we'll be talking about that in Florida and in the federal system. You have to produce the information as it's normally maintained, which means you don't have to take paper and convert it to an electronic format if that's the only discoverable document. On the other hand, if you have information in an electronic format, you you can't convert it into a format really that can't be searched or that strips away helpful and important metadata for the case. But let's keep in mind that the whole idea here is that when you're communicating with, with opposing counsel outside of discovery, yes, you want to be careful about what you're sending and make sure your information isn't more that you want to send. On the other hand, when you're in the discovery process, the opposite rule typically applies, is that you can't take the discoverable information and change it to a different format that's not reasonably usable. It would be shocking, absolutely shocking, if any attorney were to do that now. We won't say it didn't happen years ago, Ralph, but presumably it's not going to happen any longer, thanks to the rules that Kevin and his committee have put together for us.
I'm going to back up and get, I guess, a little less technical and talk about the rules of professional responsibility, because that's part of what we're doing today. The Florida Rules of Professional Conduct 4-1.6, and again, all of these are in your citations with descriptions along with them, require you to protect your client's confidential information. The Florida Supreme Court has passed now administrative rules that require you not only to protect your client's information, but third-party information before you put it into a court record. You're obligated to know that. Also, in Florida, metadata has a special status under ethical rules, and it's a little bit different in Florida than elsewhere. If you send somebody something and it has metadata attached to it, they're not allowed to mine that metadata unless, of course, it's in the course of discovery. And it actually says that in the ethical opinion, which we've cited, which is 0602. Again, these are in the list of citations. So if you receive something from the other side is in a format that you know they didn't intend that you were supposed to get, then you're not allowed to look beyond the document itself, and you should let the other side know. And this is no different than paper, right? If I sent you something in an envelope that was a communication between me and my client, your obligation is to stick it back in the envelope and pick up the phone and tell me about it.
Well, let's even go a little bit further, Ralph. Suppose that you had a communication with your client on a piece of paper and you sent over a draft settlement proposal you wanted your client to authorize, and you had a settlement for $100,000, and your client crossed it out and said $50,000, you wouldn't put that same document in an envelope and send it to the opposing side. What you'd do is you'd clean it up and make sure that the right information was sent. That's all we're talking about.
Well, I have to interject one thing, and that is, as a Florida lawyer, and you're ever communicating with lawyers outside of the state, beware of the fact that this is a unique Florida thing, that you can't look at the other lawyer's metadata. In other states, you do, and they will look at your metadata. And in fact, it's considered part of the duty of competence to know what writing that they're receiving. And Florida's a little different, I guess, cutting people slack. If you mess up and you accidentally include metadata you didn't mean to, like, for instance, how much you're willing to settle the case for, and you get this, you're not allowed to look at embedded comments under Florida ethics codes. But beware of the fact that in other states, I would say the majority, they think that this rule is a little silly, and in fact, they will look at your metadata. So be careful, follow other Ralph's comment, and that is be competent. Don't share your secrets. You got a duty of confidentiality. Know what you're sending to another lawyer.
Well, the duty of confidentiality overrides the fact that the other side is supposed to send this stuff back. Sometimes you can't unring the bell, and if you give up a trade secret or confidential information to the other side that you didn't intend, then that's on you. And the rules of professional responsibility 4-1.1 say that you have to be competent in handling that, and the ethical opinions and rules that we've cited to you cover this. But the teaching point for us is that you have to understand that when you do something electronically, you're sending more than just what's on the face of that. What you see on your computer screen is the tip of the iceberg of what you're sending to the other side. So you need to understand that. And it is your responsibility to protect it. Now, privilege is a special part of this problem. Privilege is creates special problems for electronic discovery, and we're going to talk about that in a minute because privilege review is a very expensive thing to do. But if, for example, you send something inadvertently to the other side that's privileged, say there are lots of electronic documents and something gets included, we now have a rule, which is Florida Rule of Civil Procedure 1.285, which has a specific process by which a party, person, or entity may retrieve inadvertently produced privileged information. Now, there can be a challenge from the other side that you really didn't do it inadvertently, so there is a process on both ends of the equation. That was not part of the current rules for electronic discovery. That was adopted about a year and a half ago, but Rule 1.285 is an important rule, and it's in the background for what we have here. But there are ways that attorneys can protect themselves against a privilege problem, which is called a clawback agreement, where you can make arrangements with the other side. Do one of you want to talk about that?
Well, unfortunately, to some degree, the Florida courts have not adopted a clear rule such as Federal Rule of Evidence 502, which kind of standardizes this process across the federal system. Nonetheless, and we're going to talk about Rule 1.200 soon, which is a case management procedure in Florida courts. It's important to address the issue of inadvertent disclosure of privileged communications up front, and in virtually every case involving electronically stored information, which means just about every case, because the volume of electronically stored information is so significant, and the search and culling methods, it's not perfect. We're dealing in a world with imperfections, and when you have large volumes of information, you're trying to cull them, you're trying to review them, you're doing the very best job you can. You're going to have information is going to leak out. It's going to become distributed to the other side inadvertently. So it's absolutely critical in your cases to talk about how we're going to handle this under the rules. And typically in the federal system, if there's been an inadvertent disclosure and procedures have been put in place regarding quality control and the like, that's deemed not to be a waiver. I would recommend all Florida attorneys in your cases enter into a similar kind of stipulation with the opposition, just so it's clear that in those sorts of cases, there's not going to be a waiver that takes place.
This is one of our advanced tips, right? I mean, this is something where cooperation with the other side. Ralph?
Yeah, I'll bring that down into the weeds a little bit.
Yeah.
Most of you have a standard type confidentiality agreement in order that you're using in your litigation. Make sure that you add a paragraph to your standard confidentiality agreement that tracks and brings in Rule 1.285, brings in the clawback provisions, another takeaway word, clawback. You're clawing back the procedures of any accidentally disclosed privileged information, or it can be expanded to accidentally disclosed confidential information. Maybe you meant to redact it, but you were producing 20,000 documents, you made one mistake. So this ought to be a practice tip. You ought to go back, take a look at your confidentiality agreements and orders, and make sure you have a good clawback provision in there. Or sometimes you may want, and this has to do with strategy and whatever the particular case is, you may want to have a standalone clawback agreement and clawback order. But you definitely, in any case where you're having any substantial amount of exchange of information, you're probably going to want to have a clawback agreement, and it would be a good idea to bring this in front of the judge and make sure that the court is aware of it too.
Well, it's interesting because it takes a long time for privilege review. So if somebody wants something quickly, then that's a negotiating point, I guess. You can say, well, look, I can get it to you, but it's we want a clawback agreement. Is that?
Well, there's a couple ways of going about that, and most attorneys aren't too impressed with it, and that known as a quick peek agreement, where you let the other side take a look at information that maybe you haven't even fully reviewed for privilege, and with the understanding that if there is something privileged there, they're going to be able to, they'll have to return it to you and not use it. Of course, the danger with that, as I think you mentioned earlier, once the bell's rung and the other side sees it, it's information that's been disclosed. So that's a practice tip that most of us frown away from. We don't think that's an especially appropriate way to go about it. There's other ways to stage and tier and structure the production of e-discovery, Ralph, that I think we'll talk about later, but I think it's a better approach.
Okay. Kevin?
I was just going to make that exact point, that one of the things you can't do as an attorney is just assume that if I have a clawback provision in my confidentiality agreement, that somehow obviates the need for me to do privilege review. You still need to spend the time to go through those documents and make sure that your client's information is being protected, because the fact that the other side can't use it directly against you in court doesn't mean that it's not known to them now, and it doesn't still have a big impact on how they approach the case. As you said, you can't unring that bell. So it really is critical to make sure that you're doing proper privilege review beforehand. And that's one of the big problems that we have to deal with as we go forward with these rules, is we have to have good understanding between lawyers and obviously between courts and lawyers as to what is the proper scope of production and what type of privilege review will go on and what can we do to control the costs of that privilege review, because oftentimes that becomes one of the big driving forces in this discovery, is when the amount of time that has to be taken by lawyers to review these documents that are going to be produced, or when the dollars that are involved, if that drives the bus, then that becomes a problem where the discovery can overwhelm the case.
Okay, and we're going to talk about that in some detail. Let's shift back again to the second new rule. Well, we've covered 1.280B3. Now let's go to Florida Rule of Civil Procedure 1.350, production of documents and things. And it's in the handout 1, it's pages 16 to 17 in the left-hand column. Kevin, what was the purpose of making a modification to the production of documents and things?
Well, obviously, we have a rule that requires you to respond to requests for production, and we wanted to put in there explicitly in it that you could request them to produce electronically stored information. So you now have that added in to 1.350A. And we also needed to have a format or a process that would be set up to resolve disagreements about format. And that is one of the problems that you run into sometimes, is that you make a request to someone and you say, send me these documents, whether it's emails or whether it's something that's a history of when a particular machine was turned on. And the other side may have a different view as to what format that should be produced in, as opposed to what you think it should be produced in. We wanted to have a way to resolve those disputes without involving the court in it every time. We don't want lawyers to have to run to the court to solve it if they can solve it among themselves. So what 1.350 does is it says that the request for electronically stored information may specify the form or forms in which electronically stored information is to be produced. So if you're the party sending out the request for production, you say, I would like this in a reasonably usable format, or I would like it in its native format. Now, if I'm the person responding to that request for production, I can then rely on the next sentence, which says, if the responding party objects to a requested form, or if no form is specified in the request, the responding party must state the form or forms it intends to use. So let's say you told me that you wanted it in native format, and I think that's just improper or way too expensive or burdensome. I might say no, but I'll give it to you in reasonably usable format. Well, now we have a dispute. How are we going to resolve that? And what the goal of the rules is for those parties, those two lawyers, to get together and to try to talk it out and agree on which is the proper format. But knowing that lawyers are lawyers, we know that you won't always be able to agree. And so the rule then provides that if there is a disagreement and you're unable to resolve it, you can then take it to the court.
Okay. Why is the form of production so important, and why should we spell this out in our rules?
Well, Ralph, I think it's pretty clear that from our previous discussions that how you obtain the electronically stored information from the opposition is critically important. The form determines in many cases the content. So depending upon what form you're getting it in will also determine the content, what exactly you're getting, as well as how accessible that information is going to be for you.
By accessible, you mean, can I search it?
Yeah, well, exactly. Well, let's take a classic example of an Excel spreadsheet. What you could do to produce that would be to basically print it out to paper. And if you print it out to paper, you're going to see the values in the various fields. But what you're not going to see is the underlying formulas, which are critically important. That will enable you quickly to understand how the values that are showing up on the paper were created. So in those circumstances, it would be a disaster, frankly, in terms of cost probably, to get an Excel spreadsheet that's not in a native form or some kind of production format that allows a disclosure of the underlying formulas that to create the values in the cells. So that's why you want to negotiate format early on. And the format can range from a native, which is basically the original files as they would be seen on the application that created it. For example, a native file would be a computer file that you have to open up and see in Word when you look at it, to near native. To near paper, which would be a TIFF image or just a picture, to a paper, which eliminates most, if not all, of the metadata associated with it. So those, 4 basic choices we're talking about, and with variations between them, are critical for counsel to negotiate, because what you're really talking about is what you're going to get.
Okay, but let me ask you, do you have to show that what you're asking for is relevant before you're entitled to get it? In other words, the fact that you need the information about the formulas behind it, do you have to show that that's relevant before you can request it?
It depends upon the cases, which is always a good lawyer's answer. I mean, for example, maybe it's not important in an email to have all the internet header information, but the truth of the matter is it's very difficult early on in a case to predict what information is going to be important or not. It's very difficult to predict what information is going to help me move through the data more quickly in terms of my analysis. So it seems to me that the default position of most lawyers ought to be that metadata, or most metadata in the case, is going to be relevant. Now, that doesn't mean I need every computer log within the computer. It may not mean that I need every particular, for example, a font that a Word document is produced in, but I sure am going to want, the basic, when it was modified, access, and created information for every electronic file, and we can take it from there. So there's a series of metadata fields that are going to be important for almost any case, and then beyond that, there may be others that happen to be important.
So teaching point number 1 on this is, if you're requesting something, you should specify the form of production that you want, correct?
Absolutely.
Right. I mean, you got the ability to do it. There's no reason not to, right?
Correct, and it would seem to me that if you haven't, and here's the real danger, that what we don't want to do is go out and start requesting metadata and electronically stored information wildly, if you will. You've got to, there's not an absolute default position. You've got to think about your discovery requests, perhaps more than we used to. Maybe 10, 20 years ago, we were saying any and all relevant information about this particular contract or person or event or circumstance. We've got to be a little more focused and talk about what kinds of documents you have, what metadata is relevant in those documents, which leads to the whole process of dialogue, which we're going to get into a little bit later. It's very difficult to do this on your own without having a dialogue with the opposition to talk about what kinds of metadata they have, how the information is created, how it's stored, and how it's preserved.
If you're the responding party, then, if you don't intend to produce it the way it was requested, you're to object, right?
Absolutely.
And if you don't object, what's going to happen to you?
If you don't object, then the court may look back to the rule and say that they've requested it in that form. You did not object, therefore you need to produce it in the requested form.
Again, so you may produce it in something they didn't request,
Exactly,
because that's the way you wanted to give it to them, and you may have to produce twice.
So now you bear the burden of having to produce twice, and the court is not going to be real sympathetic to your request to have them pay the cost of the second production. They're going to tell you, no, that's your fault, because you didn't follow the instructions, which were to produce it in this format. And I think that format is so critical. The rule also provides that if a request for electronically stored information does not specify the form of production, the producing party must produce the information in a form or forms in which it's ordinarily maintained or a reasonably usable form. And I think some lawyers may be saying, well, why couldn't the committee pick between those two possibilities? Why can't we say that the default position should be A or it should be B and make up our minds? And I think the answer is that it depends on the circumstances. There may be some cases in which it's much better to produce it in a reasonably usable format. There may be others in which it's absolutely critical to do it in a native format. And I think that might be something for Ralph Lozier or Bill Hamilton to talk about in terms of some examples of those.
Okay, or less expensive to produce it.
Yeah.
Well, yeah, let me connect a dot here. In the rules, it says ordinarily maintained. That's the same thing as original condition, or what we've been calling native files. For example, a Word document most people are saving a Word document as a Word document, a DOC extension type file, a Word file. So that's how it's ordinarily maintained. But in some circumstances, they may not, after a certain point in time, it may be archived out. It may be, in some companies, actually print out certain documents, and they don't save the original Word file anymore for certain types of files. And at that point in time, it's ordinarily maintained just as paper. If that's all that's left by the time they get a production request, then ordinarily maintained may not be the original native file because that's been deleted before there was ever notice of the lawsuit. And we're going to get into that whole question in the other rule that we now have in Florida, which is very helpful. But anyway, so ordinarily maintained is just how you find it at the time the request hits or at the time the duty to preserve triggers, which is a little bit muddy here in Florida, but it's how you're keeping it in your record system. Could be as a computer, could be as a paper record. Whereas reasonably usable form is not the way you originally kept it, but the way it may be better to produce it. Now, the main example that you use of this to understand it is like a database. So, I don't know, maybe payroll records. You're keeping records of all, let's say, 100 employees of the company, but only 4 employees are actually going to be relevant to this lawsuit. The other 96 are not relevant. Well, the way it's originally maintained is all together. And so, you're not just going to produce all 100 employee records. It's not relevant. It raises all kinds of privacy rights, et cetera, et cetera. You only want to produce the 4 that are relevant. That's all that's reasonably usable here. And so you would then change the format. You would usually export it out as a report, typically an Excel spreadsheet or some other kind of report. Now that's reasonably usable to the recipient. Another example of that is, what if your client got a special program, a database that their son-in-law created for them, and the only person that can read this is them? It's a proprietary system. Or what if you're representing a huge corporation, they built their own software? Well, you could turn over the native format to them and nobody will be able to read it because it's very specific. That used to be a huge problem back in the 90s when there was all kinds of different kind of computer programs. Now we've got some standardization, but it's still a problem. And, you could, as a requesting party, you get produced something, what are you going to do with it? You can't use it at all. So there are occasions when ordinarily maintained could be not reasonably usable. And so the parties need to talk this out.
There might also be differences in those formats when you talk about what they're actually going to receive and how easy is it to Bates number it, how easy is it to redact it. Maybe you could talk about that a little bit more.
Yes, I'd be happy to. One of my little pet peeves, though, is the Bates stamp. Don't get me started on that. The Bates stamp, was invented in the 1890s, and yet here we are in the 21st century using an invention that Thomas Edison bought back in 1897. He bought it. We're still using the Bates stamp. We're not actually stamping it like I did when I was a young associate. When the secretary wasn't around, I was Bates stamping. And yet we're still doing Bates stamping, though, electronically now, just to keep track of a production. You can't Bates stamp an originally maintained file. You can't add a number to a Word document. Well, you could do it, but you'd be changing the document itself. And so the typical protocol that's been developed now in the electronic discovery vendor industry, and we've gone this far without talking about it, but we need to talk about it, and that is most productions nowadays, you're going to have someone assisting you who is an expert in the actual production process, an electronic discovery vendor. It's as important today as the copy shop used to be in the past. And in any large-scale production, you're going to be using some kind of vendor to help you make sure that the format is reasonably usable and to maintain an identity of Bates stamping electronically so you can keep track of it. There's another thing which I won't bore you about here, but if you're interested, there's an alternative to a Bates stamp called a hash logarithm, because each computer file has a unique hash signature. It's a special unique identifier of a computer file, which is kind of interesting to those of you who care about authenticity of evidence, getting evidence admitted into trial, is there is an ability to authenticate every computer file by knowing its hash value, and it's something that can easily be done These programs are free, and you can authenticate a computer file through a hash value. Wrote a law review article on that. Hash, the new bait stamp, University of Florida publication. If you want to get it, it's on my website. So there are ways to authenticate computer evidence that are unique to computers. One of them is using hash values. All, getting back to what's reasonably usable. And I think, Ralph, this is the biggest waste of resources. I mean, millions of dollars every year are spent by litigants across the country arguing and litigating over form of production. And to my perspective, this is all just a technical thing. There should never be any arguments about form of production. It's pretty obvious what's reasonably usable or not. When you get people that are technically knowledgeable, they can work it out. And if you have a vendor helping you, they can work it out with the vendor on the other side or with someone with technical competence. You can work out these questions of form of production. And believe me, be very careful before you start spending tens of thousands of dollars arguing over form. To me, there's just no point in arguing over form. This is something that you should be able to work out, and with the help we now have from the rules, you should be able to work out what's reasonably usable or not. I mean, I've never seen experts really fight about this when you get down to the brass tacks of what's involved.
Yeah, just one gloss on that, Ralph and Ralph Articler, is there is an intermediate zone, just so we're not confused between producing in a native and producing in paper. And that's a format that's been developed that, frankly, most governmental entities request the information to be produced in if you have a case involving a governmental entity. And many law firms use the same format, where what you do is you provide a TIFF image, which is a picture, which you can put a number on, and use that document at depositions, at trial, and the like. But in addition to the TIFF image or the picture, you also produce it associated with a database that has selected metadata in it that can be searched. So you have the TIFF image, then you have what's called extracted text, which is the text from the original file, plus the metadata from the original file, all which is searchable. And the two classic formats for that are products called summation and concordance that do this, that are widely deployed over the past 10 years for that process. And that's kind of an intermediate zone. And there's, there are good reasons that you want to use that format in certain kinds of cases, because sometimes it's easier to keep track of the TIFF images during the deposition and trial practice rather than using native formats. So there are different alternatives that should be discussed, and the price points associated with each should be discussed as well, because when you're turning native files into a TIFF image and extracting the information, there's a cost associated with that vendor is going to charge. That raises the issue of a load file, and when people talk about a load file and negotiating a load file, that's what they're talking about, is when you give it to me, what's it going to look like so that I can load it into my particular software and see it and operate it, so I just don't get raw data that I can't use. It has to be handed over in a particular format that can typically be loaded into some kind of review software, and that's, again, called a load file.
Kevin.
One of the things I wanted to ask both of you is, one of the goals of this subcommittee was certainly to make these rules usable for everyone to the extent we could. And a lot of what we're talking about here so far is focused on sort of some high-level things we do in large discovery productions and things where we have an e-discovery vendor. But there's many Florida lawyers that practice in small firms that do litigation in a one- or a two-person firm, and they need to be able to understand, I think, what they should be thinking about as they approach litigation under these new rules if, for example, their client doesn't have the resources to be able to afford an e-discovery vendor, or if they're going to have to do it the first time.
Let's hold that thought, because we're going to take a break here. And when we come back, I want to discuss how this rule is applied in the smaller case, as we've discussed, and then we'll get on with how this rule is applied with regard to interrogatories, the rule of form of production. So thank you very much. We'll take a break. Okay, when we took a break here, we were going to talk about small firms, small case situation, and we are going to get to that in a second, but I would like to dispose of and handle another rule change, which is 1.340, interrogatories to parties, which allows for the production of electronically stored information, just like you could give paper instead of interrogatory answers. Now you can give ESI. So how did you handle form or format with regard to that?
That's correct. And, you know,
that's on the handout, page 14 is Rule 1.340.
Many lawyers probably realize this already, but 1.340C has been there for a number of years, and that's the option to produce records instead of responding verbally to an interrogatory. If you can say that, you know, the knowledge that you're seeking in this interrogatory is equally ascertainable to you, if I just turn over these records to you, you can turn over the records in lieu of an answer. What we've done with that particular provision is to add in a specific reference that may include electronically stored information. The subcommittee then felt that if we're going to allow people to produce electronically stored information and that we're going to make that explicit, we also ought to put some, you know, very careful caveats in there as to how you're going to do that. And those caveats are essentially the same as what you find in 1.350, that if you're going to turn it over, that information should be produced in a form or forms in which it is ordinarily maintained or in a reasonably usable form or forms. We don't want people to have more ability to play games under 1.340C than they have in 1.350. So it's essentially the same standard.
Okay, so I'm a lawyer now. I mean, it's easy for us to say, okay, reasonably usable form, easy for us to say native form and so forth. But what does that mean for a small practitioner? Ralph, I'd like you to address this question for us. You've got a smaller case, and the electronic evidence is important to the case, but it may not be as voluminous as the big case where you're talking about load files and TIFFs and things like that. So how do you address that?
Well, what I call my blog is called eDiscovery Team, and it's one of the things I've been advocating for quite a while, and that is to use a team approach to practice of law in the 21st century. And back in the 50s and 60s, it seems like every favorite Supreme Court justice nominee's TV show was Perry Mason. And there you had Perry had his Paul Drake. He had a private detective. He had a team approach, and he had what was her name? Stella?
Della.
Della. I'm not sure what her role was, but whatever. It was important, and it was a team approach. We still have a team approach in the 21st century, but now you need to have the nerd down the hall. You need to have the tech guy. And so part of, even in a small case, you need to maybe hire one of Bill's recent graduates from the University of Florida, or other state schools also are offering eDiscovery. You need to have somebody that has some background into the computer science of what's going on. The example of the horse manure case. The lawyer didn't actually think of that himself. He didn't know, but he had somebody on his team that knew enough about the iPhone to know that there was a GPS built into it and you could get it off of that camera. This was not a big case, but he had a local expert, a local vendor. They charge by the hour. It's not a $100,000 bill. It's like $50 an hour, $100 an hour, cheaper than your private detectives, and they can give you some advice and help you out on this. And so that's part of the team approach. Even in the small cases, you may want to bring in a vendor, unless you're foolish enough like me to stop practicing law and just do eDiscovery for years and years. Get somebody who does know something about the IT part of it, and they don't have to be a lawyer, but they have to know enough about how you can produce something in an ordinarily maintained format, which means native, which is the cheapest way to make any production. You just copy and paste and put it on a CD. That's the cheapest way to do things. May not be the right way to do something in a particular case, but it is possible to do eDiscovery on the cheap. A good friend of ours, Craig Ball, is always writing on this question, how do you do eDiscovery really cheap? How do you do it in the $10,000 case? That's another resource you might want to look at, Craig Ball, online. You can Google him. He comes up with some program software you can get. There's one I saw just the other day. He was writing about a $100 search program that you can download and put onto your computer and do your own searches. So I advocate a team approach to get someone with technical expertise to help you find out how to do e-discovery in a smaller case. And of course, the same thing applies, but magnified. If you've got your $1 million case, if you've got your $10 million case, you definitely need experts to assist you. I'm not talking about lawyers necessarily. I'm not trying to promote myself or anything like that. I'm talking about e-discovery vendors that know the technicalities that'll help you deal with these format issues in the large case where you may be dealing with millions of files, down to the small case where it may just be one photograph you've got on an iPhone and you're not sure how to get it off that iPhone and into evidence. And there are people in pretty much every town in Florida that have this kind of computer expertise, and if not, you can find them in the larger cities that'll help you do these things.
Can we talk a little bit about the games people play? I mean, as far as form is concerned, did you want to talk about the Bray and Gillespie?
Well, I do want to talk about Bray and Gillespie if you'd like me to talk about it now. That is a gamesmanship case if there ever was one.
Okay. Do you want to talk about that in sanctions? Or?
Yeah,
let Bill's got something to say, and then we'll go into that.
Leading into Bray and Gillespie, I think it's important to talk about the small case a little bit more, because I agree with Ralph that you can find assistance out there in the way of technical expertise at a relatively modest cost. And you have to do it right, but it's not necessarily the rocket scientist approach to things. One of the issues you're facing in a small case, for example, is let's suppose you've got a couple of custodians and they have email, and you have to find the right email in the case for those particular custodians. Now, one of the ways to do that, of course, would be to say to the custodians, go and find me the emails, and going back 6 months, 8 months, a year, or however long your email files go back, by using the search tool in Outlook. That's a really primitive way of going about it, and it's a dangerous way because you're going to miss a lot of data, and it's really not very legally defensible. And down the road, if you get called on it, it could be a severe problem for your case. So you're going to have to figure out a collection and search methodology. So you really do need some basic, inexpensive e-discovery tools. They are out there. This is not a seminar on e-discovery tools, but the one that Ralph mentioned is out there. It's $100 to download it onto your own personal PC, and then it does wonderful searching. High-powered stuff lets you get your hands in it. Doesn't take a lot to learn how to do it. I taught myself in a few hours how to operate it and run it. It's a great program that's being offered. It's not the only one. Other programs out there, that particular product, I will name it. It's Nuix. It's called Prooffinder. Super product. DT Search has a product out there you can download for $200 onto your own computer. So there's products out there, and you really need to use search tools to do that, because if you use Outlook to accomplish that process, you're going to miss a lot of stuff. You're not going to have the proper, what we call recall, is that getting the responsive information back, and you're not going to have the proper precision. So you're going to be looking at a lot of junk and collecting it that's worthless, and you're going to be missing a lot of stuff that's important. You're going to get caught between a rock and a hard spot. And then once you use these particular products, the Nuixes, the DT Search, or others that are out there, then what you can do is you can turn it over to the other side, and you don't have to create load files as was suggested by Ralph Artigler. What you can do is you can turn it over in native, but you have to have a technician to be able to say, how do I make the hash value of it so that I can keep a record of it, and how do I make sure I keep a copy of what I'm turning over, and basically negotiating this process with the opposition.
And how do I not alter the document in producing it, right?
And how do I not alter it in producing it? Exactly. And in some cases, you're going to leave some of the metadata behind that Ralph Losey was talking about. You've got to discuss that with the opposition. Most metadata is not relevant to most cases. That's the simple truth of the matter. That doesn't mean you can forget about it, but it does mean you have to talk to those people we don't like to talk to. Who's that? The opposition. Litigators are not good at talking to the opposition, primarily because we think we're playing a chess match with them, which we are. But in cases of e-discovery, we have to have that dialogue early and often to protect ourselves. So there's ways of doing e-discovery in small cases, Kevin, that make a lot of sense, but don't think about doing it the old-fashioned way, like printing things out to paper or doing custodian self-collections. You've got to go grab that email. You've got to have basic elementary search tools, and then you can collect the information and produce it in a native format. That was suggested by Ralph after you hash it.
I think that's very important, and I think as representative of the committee, I certainly want to emphasize that our vision was not that everyone has to go out and make yourself familiar with new programs, not that you have to have an on-staff vendor at all times ready to do e-discovery for you. But you do need to know some of the basic terms. You do need to know what is happening when you go search for email. You do need to know how it's stored. Part of that involves learning from your clients. What they don't know about the programs they're using, you're going to have to find someone to be able to explain that to you. But that knowledge is part of your duty of competence. That the same way if you're going to do a medical malpractice case, you're going to have to teach yourself a little bit about medicine in order to competently represent those doctors. When you start dealing with evidence that's electronically stored, you're going to have to teach yourself a little bit about how that evidence actually sits in that computer. You have to find somebody who can help you do that. It might be, the person down the street who's a specialist in this, who has a very expensive e-discovery business, but it also might be someone who's just a regular, computer technician who knows a few things. Again, you have to make a judgment as to whether that person is competent to advise you. You do have a duty, I think, to keep your costs down for your client, and you're going to need to go out and seek different ways to get this information. But there are a ton of resources out there. A lot of them are mentioned in our glossary. And the ultimate idea is once you know some of the basics about this, you can then decide what agreements you need to reach with the other side. Because if you don't want to swamp your case with costly e-discovery and many, many e-discovery vendors, if you're worried about those things, that's a reason to talk to the other side early and suggest that let's limit the e-discovery in this case to X, Y, and Z. But again, before you make any kind of limiting agreement, you need to know the basics well enough to know if you are cutting off a very important source of information for your client's purposes. So don't just automatically say, well, the way I'm going to deal with these new rules is to just go and talk to the other side and say, hey, this new e-discovery stuff really isn't much fun. Let's just agree not to use it, because you might be hurting your client's cause when you do that. So know enough to know what deals you need to make, know enough to know what you should ask for from the other side, know enough not to get into trouble. That's the idea. If you can do that, there are enough tools in these rules for you to get help from the courts so that you will not get swamped. Just because you're going up against a big company that has a ton of experts and that has a lot of people on standby to do this doesn't necessarily mean they're going to be able to overwhelm you. So know where those tools are.
Let's talk next about the rules that were placed in here to limit the amount of discovery, because when you say the scope of discovery includes electronically stored information, it's subject to these rules. And then 1.280D, which is on your handout, page 11, middle to the bottom on the left-hand side. Tell us a little bit about that, Kevin.
Sure. I think this is probably the most important of the various rules that were adopted, because this is where you're going to get the most help in resolving the disputes that you might have with the other side. 1.280D has two subsections, and they both come under the heading of limitations on discovery of electronically stored information. Subheading 1 is about when you can object to the discovery of ESI. And it says a person may object to discovery of electronically stored information.
Now, person means either a party or if you receive a subpoena too, right?
Absolutely. So a person may object to discovery of electronically stored information from sources that the person identifies as not reasonably accessible because of burden or cost. And that part of the rule means that you're going to have to be aware of what the burdens are or the costs are of the discovery that is sought from your client. Again, that goes back to educating yourself and becoming competent in this area. If you identify those sources, let's say the person asked for your entire database going back 5 years, and your client says there's no way I can shut down my system long enough to do that. It would just kill us. You then can say, well, that's not reasonably accessible, and you raise that objection, presumably in your response to the request for production. It is important, obviously, to make the objection and to preserve that concern. The other side then can say, well, that's very critical to my case. I really need that information. And they may file a motion to compel. And this is where the second line of the provision becomes relevant. The second line says that on motion to compel discovery or for a protective order, the person from whom discovery is sought must show that the information sought or the format requested is not reasonably accessible because of undue burden or cost. What that essentially means is that if you're the one that raised the objection, you bear the burden initially of sustaining it once it's challenged on a motion to compel. If you make that showing, the third sentence becomes applicable, which reads, if that showing is made, the court may nonetheless order discovery from such sources or in such formats if the requesting party shows good cause. And that good cause standard is what's critical here. That even if you're right, even if that would be very harmful for you to shut down long enough to produce that information out of the computer, the court can still say, in this case, it is so critical to the outcome that we're going to make you do that. And you then might have some things that you would say, which would be along the lines of, well, judge, if you're going to do that, then at least make them pay us for the cost or for the time involved or whatever. And you would look to the fourth sentence of D1, which says, the court may specify conditions of discovery, including ordering that some or all of the expenses incurred by the person from whom discovery is sought be paid by the party seeking discovery. So that first rule is where you find the basic procedure of you're going to have to raise the objection and say it's not reasonably accessible. The other side can challenge it. You, as the responding party, then have to sustain that showing of not reasonably accessible, and then it's their burden to demonstrate good cause to get it anyways, at which point the court can talk about the limiting factors. That's D1. I'm going to go to D2 real quick, and then we can talk about the implications of all this. D2 is where you find some very, very important things that are in some ways new to the rules and that they are explicitly in here for the first time, but they have been part of our case law for a long time in terms of our common law case law. What 2 says is that in determining any motion involving discovery of electronically stored information, the court must limit the frequency or extent of discovery otherwise allowed by these rules if it determines that 1, the discovery sought is unreasonably cumulative or duplicative or can be obtained from some other source or in some other manner that is more convenient, less burdensome, or less expensive, or 2, the burden or expense of the proposed discovery outweighs its likely benefit considering the needs of the case, the amount in controversy, the parties' resources, the importance of the issues at stake in the action, and the importance of the discovery in resolving the issues. This is where we find the proportionality rule. And what this is the best resource you have as a lawyer who is concerned about being overwhelmed by unnecessary or burdensome e-discovery. This is where you can get the help from the court to say, Judge, in light of what's at stake in this case, what they're asking for is simply too much. It is not necessary. I'm going to turn it back over to Ralph to take us into some further applications of this.
Well, proportionality is found in common law in Florida, and the citations are in your list of citations. There's the Chrysler case, and that was all the way back in 1983, and that's not an e-discovery case, but basically the court's saying you can't do tens of thousands of dollars worth of discovery over a car that's worth $8,000. I mean, that's basically what it says. The other thing that Chrysler says, that the case says that's important, is that the judge can't take the word for the lawyers on what is burdensome or excessive. So it gives us two prongs on this, and we're going to talk about how you prove this in a minute. The other is the Alvarez versus Cooper Tire and Rubber Company, which is an electronic discovery case, 2011. The trial judge has substantial leeway and discretion to fashion limits to discovery that permit access to discoverable information while still preventing overly burdensome discovery. Otherwise, the cost and burden of civil litigation will imperil its very existence. So proportionality is built in to our common law. It's also built into the law in federal courts as well. But here we have a very clear and good expression in the rule. But I want to dissect this rule on the accessibility and find out from the two of you, and I want you to tick them off because we have a lot of things to cover. But when you talk about lack of accessibility, what are you talking about?
Well, lack of accessibility, it's a technical term, and it's a term of art that's really been developed very nicely under the federal rules that's been appropriately adopted in the Florida rules. And accessibility means, you kind of gather the meaning of it by looking at the kinds of examples of what have traditionally been called inaccessible data. The first kind of traditionally inaccessible data has been essentially information that's on a hard drive of a computer that you can't see on the screen, that requires a forensic analysis in order to obtain and to extract from the computer. That requires you go in, you have to hire an expert, you need additional software. It's a process to obtain it. Another kind of traditionally inaccessible, not that you can't get it, there's just cost and burden associated, would be information that's pulled out of what's called a legacy system. This may be an old computer sitting in your closet that's running on an operating system from Apple or Windows that was generated back in 1999. There's data on it, but getting that information off the computer is going to require some specialized software to extract it and to use it. Another form of inaccessible data has been held to be information stored on disaster recovery media, otherwise known sometimes as backup tapes if it's used for disaster recovery, especially in the old days when backup tapes were literally tapes that would collect information almost in a quasi-serial fashion. So those data locations have historically been determined by some courts to be potentially inaccessible due to burden and cost. So what this concept is that there's some information out there that may be difficult to retrieve, it's not readily available, and if it's going to require something not heroic but short of heroic to obtain it, then maybe it's going to be, we're going to have to take a closer look at whether it's going to be appropriate for the case and who's going to bear the cost associated with that inaccessible data. The trick here, though, and I'll pass this hard part on to our colleague Ralph Losi in a second, the trick here is that all of those locations that I've mentioned just a second ago, as technology develops, are becoming increasingly accessible. Especially disaster recovery media, where now it's more easy to, when you have backup recovery media, to focus in on a particular custodian or a particular location of a company rather than restoring an entire set of backup or disaster recovery media going back over a period of time. I mean, are you finding that in your practice too, Ralph?
Yes, I am. In fact, I wrote an essay once on the federal equivalent of this rule. This is derived, those of you who know the federal rules already, this is the almost word for word from 26B2B. And this is a very important protection for anyone from undue burden from e-discovery. And, it doesn't say inaccessible. A lot of people will say, well, this is a rule, you can't access it, you can't get to it. Well, with enough money, you can get to anything. The NSA boys can get to things that have been completely wiped on hard drives. But it costs money. And is it really worth it? I mean, to look at stuff, what's the value of it in a particular case? And this is, it all depends. In $1 million case, it may be worthwhile to spend $10,000 on a forensic expert to try and retrieve the data, as Bill mentioned.
That's the good cause element.
Yeah, it may be, and that's the proportionality that we'll get to. I mean, this rule is key. This is a rule you really got to know and understand, 1.280D. Both subsection 1 and 2. These are, I think, something that is really going to make e-discovery be less painful for the state of Florida and prevent, a David and Goliath situation on both ways, so that people can't game the system, use e-discovery as a weapon, which is something that all of us are very concerned about. We want cases decided on the merits. We don't want them decided on the fact that, well, it may cost too much to defend because it costs so much to do e-discovery. This has been very much in the minds of all of us, is that we want cases to go to trial on the merits, not to be settled because, gee, I can't afford to actually look on the backup tapes. And the point Bill's making, though, is that many companies now, the larger ones, are moving away from backup tapes so that it is harder and harder to to use this defense. But still, I would say your average case, I don't know what you think, Bill, but your average Florida corporation, they're still using emergency backup tapes. I mean, we've all got to be prepared. What that is, the next hurricane that comes, and we all saw the times when the computers are ruined. You're out of business if you don't have your computer. I mean, even the mom and pop pet store down the street, they run on a computer. Every business runs on a computer. And so you got to have a backup. And so what they do is they'll make periodic tapes of everything in your computer system, put them on a shelf, pray that they'll never have to use them. But the problem is, if they do have to use them, it's a pretty expensive process to restore the whole thing and then try and find it. And this is a classic example of what Rule 1.280D, the backup tape, is designed to prevent. So even though there is a tendency towards more advanced technology where everything is easier to get to, there's still the cost component that's very much alive, even with advanced technologies. And Kevin?
Yeah, and I think that is important to mention that there are two words there that are critical, and that's burden or cost. We tend to think of cost and burden as being synonymous, but they might not be. There might be situations in which your IT guy says, oh, no problem, I can print that out. If you give me, 12 hours, it won't cost you anything. I just have to let the computer run for 12 hours to print out this information. But if that involves shutting down all of the entire operation for 12 hours, that may be critically burdensome to the company that has to shut down for 12 hours to allow that process to run. Likewise, let's say you're a small business and you've taken advantage of some of the new cloud technology and all your data happens to be stored on someone else's server and you just access it remotely, okay, because maybe you purchased a service that allows you to keep your information in some system where instead of being stored on your computer in your office, it's in fact stored somewhere up in Washington, D.C., where that vendor is located. If your opponent asks you for the information about where in your servers that's located, or asks you for critical information that might be found only on those servers, you may have some strong burdens that get in the way of you being able to get to that cloud vendor, have them produce that information to you. And those might all be things that need to come up.
Okay, so I'm a judge in a case, and burdensome and proportionality and the problems with this e-discovery comes up. One point of form is that I can't take the lawyer's word necessarily for the fact that this has occurred. So you're going to have to be prepared, whether you're showing accessibility, whether you're showing burdensome, whether you're showing the good cause from the other end. You may be required to put some expert testimony on, or at least technical testimony, it's going to be a finding that's going to be based on evidence. Now, that's not in the rule, but it's something that is going to be part of the standard.
You're right, Ralph, and we talk about this a little bit in our book, or actually a lot in our book, and it really is the big scare here, is that what happens is that this becomes more boilerplate for objections. And attorneys just start adopting the language and throwing it out in front of judges and don't spend the time educating the court as to what really are the technological issues and why you do have the cost and burden. So the issue here has got to be that if you're going to make this objection, you really need to have the basis and the foundation for it. You need to be able to explain why, to say what the costs are, how the costs are going to be incurred, and if pushed by the opposition, you've also got to have an expert typically available to be able to testify about it. So these are things that you want to negotiate with the other side, but let's not turn them into boilerplate objections that get in the way of discovery. It's supposed to facilitate discovery and rational discovery, not become additional obstacles and battle over words without content.
Bill, if there's one thing I can add to that, it's that let's say there's some judges listening to this today. The judges need to know that there's a suggestion in the comment or the committee note here that if the judge finds that the lawyers don't know enough about the matter, the judge can direct them to go back and provide more information to the court. It's found in, I think, the fourth paragraph of the note, and it says, in such cases, the court may direct the parties to develop the record further by engaging in focused discovery, including sampling of the sources, to learn more about what electronically stored information might be contained there, what burdens and costs are involved in retrieving, reviewing, and producing the information, and how valuable that information might be to the litigation in light of the availability of other information. So lawyers need to read the note on this one also and think about being prepared to answer those questions, and that's a good roadmap to what the court might want to hear from you.
That committee note is found on handout 1, pages 24 and 25. It's the 212 Amendment 1.280 committee notes. So, all right. Now, I want to, I guess, bring up another perspective here, because some of us who've been practicing 25, 30 years or been on the bench and practicing, the mantra used to be that something is relevant or leads to relevant evidence. So are we talking about a new paradigm, a new model here when we talk about proportionality and limiting the amount of discovery? And if so, I mean, how's that going to be applied?
Well, Ralph and I have been working and talking about this for many years. And maybe as a predicate for that, we can talk about one of the critical problems of e-discovery is volume. And, you know, what I've got here for us is a banker box. And when you want to talk about the volume of electronically stored information, if you printed this out and filled it up with paper, you might have, 3,000 to 4,000 sheets of paper in it. And what you find is if you printed out the information on a computer, there's about 30 of these would be 1 gigabyte of information. 1 gigabyte, 30 of these. Now, Ralph, can you hold up your computer for us for a second?
30 bankers boxes?
Yes.
Okay.
And 1 gigabyte. Now, Ralph's MacBook here has a certain amount of storage in it with a hard drive that's built into the computer that he talked about earlier. And he's got 500 gigabytes of storage on that single computer. And so what you're thinking about is that if you're talking about 30 boxes and his computer were filled up, the amount of information for just one custodian would be astronomical. Now, what we find is when we're pulling information off of custodians, we're only picking up that we have to search maybe 3 to 5 gigabytes of information. But that would still be over 100 boxes of information per custodian. Think about this. This is my old little UPS truck that I have for my kids when they were little. But this is 1 custodian. Fill up this truck. That's 1 custodian in a case. So we're dealing with massive volumes of information that we have got to cull down. And that leads us to this whole issue of proportionality. And I think we're coming to the position in litigation now where, obviously if you're going to get discovery of certain information, it's got to be relevant, but it's got to be within the bounds of proportionality. So in many ways, relevance is not sufficient anymore. It's necessary, but not sufficient. It's got to be relevant and proportional. And that's exactly what Rule D2 is designed to accomplish under 1.280. Critically important, that's the proportionality rule, which frankly, as I think Kevin said earlier, is really the heart in many ways of the rule change that we're facing, is this proportionality concept. Ralph?
It's never been that you are entitled to all relevant evidence. That's never been the law, because there's always been the whole notion of cumulative, duplicative. I mean, how many times are you going to prove the same fact? So on one level, things haven't changed, but on another level, as Bill pointed out, we now have an extreme volume so that this rule of reasonability is now coming into play, such that you're going to get the relevant evidence that is proportional to your case, where the benefit burden is always going to be weighed. This is the most important thing that came out in the rules. For the first time, we have explicitly put in the Florida Rules of Civil Procedure what's been in the federal rules for a long time. Federal Rules is 26B2C, proportionality rule, benefit burden analysis, is now in Florida rules for any motion considering electronically stored information. Not just a motion under sub 1 on reasonable accessibility, but for any motion, you're going to have to look at, is it worth it? Is it really worth it to look at 100,000 emails from 1 custodian? Do you really need to review all of them? Aren't there better ways to do this? And then, of course, the subsection 2.1, the whole business of cumulative or duplicative is also part of the factor. So for the first time, we don't have to argue, a case in 83 about particular hardware, particular things. Now we've got it built into the rules, this whole notion that you need to scale down your discovery to fit the particular case, which for most cases is going to have to do with the dollar amount. Not all. There's going to be important civil rights cases or other cases that it goes beyond pure dollar. But this is going to force practitioners to do what every good practitioner's been doing already. The minute they get a case in, or whether they consider taking a case, if it's from the plaintiff's side, what's the worth of the case? What's the value of the case? And people are going to have to talk honestly. And judges are going to have to grapple with this right up front. Is this really a $100,000 case?
You're not necessarily saying that we're not going to do e-discovery. You're just saying we're going to change maybe how much of it we do.
Exactly. I mean, well, I know we got, the point is, the common sense thing is we're not going to spend $100,000 on e-discovery in a case that on its best day is only worth $100,000. There's never been a judge that would allow that before, and now it's clearly in the rules that you're going to have to make your discovery request proportional, which means you're going to have to get a handle on what's the case worth, which means lawyers are going to have to talk frankly and candidly, and judges are going to have to weigh in on it when they're faced with this problem of, wait a minute, this is going to cost me a lot of money to respond to this discovery. Now,
Ralph, if I could offer an example on that, if you're thinking about how does that apply practically when you go to the judge and start talking about what is proportional. You know, I'm an employment lawyer. I deal with Fair Labor Standards cases sometimes where you're worried about whether somebody got paid correctly. You can imagine a case where, you know, the duties test is critical and you need to know what somebody did on a daily basis. All right, let's say the person worked in a very sensitive position. They handled a lot of potentially attorney-client material, and the other side might ask you to go back and produce 3 years of their emails. Well, to review that for attorney-client privileged material and redact that and pull that out would just cost a fortune. So instead of saying, I'll produce 3 years, you might agree with your opponent to say, look, instead of producing all 3 years, you pick some dates, I'll pick some dates, and we'll do a sample. We'll sample some of those dates, and we're not going to go through that privilege review for 3 years. Maybe we'll do it for 5 or 6 days out of that period and cut it down to size. That would be an example of taking e-discovery that's potentially burdensome, making it proportional to the case. Because if there's only $5,000 to $10,000 in overtime at stake, you don't need 3 years worth of privilege review.
One thing, I'm going to give a couple of practical things here because as a former judge. Number one is, as a practitioner and as a judge, I know that a lot of times lawyers, it's sort of like when you think you want to eat the whole pie, and you take the whole pie. It really is, you never do eat the whole pie because it's going to be a problem for you. And it's the same thing with discovery. If you ask for so much, then you're going to have to review so much. And a lot of that's going to be wasted time. So you have to get the rifle instead of the shotgun. And that means thinking about it in advance. So, and actually that's doing you and your client a big favor. Because in the end result, that's the best way to go about it. So, I mean, that's number one. Secondly, I think that judges are going to be given, with this rule, some tools to deal with, one of them being cost shifting. So if I have and the problem for judges, and I'll tell you right now, when we get a discovery case, we're concerned about the fact that we're early in the case and we don't know as much as the lawyers do about the case. And we don't want to make a mistake that's going to foreclose somebody getting the opportunity to handle their case. And we don't want to make a mistake that's going to overwhelm the other side. So one of the things that we can do if somebody does show good cause is shift the cost to them. If they feel that they need something, then you can shift the cost. And ultimately, in the end result, when we get a party that wins or loses the case, you can deal with costs at that point. But cost shifting is specifically provided for in a rule. Another thing you can do, as Kevin has eloquently said, you can talk about sampling or tiered discovery. Get the low-hanging fruit, as Ralph likes to call it, first. And if that shows us that you need to go further, then we can go further. But you don't have to get it all at the beginning. And getting it all at the beginning may be not only burdensome and expensive, but it may not be the best thing in the end result. So I'm just very enthused about the fact that we have a structure to dealing with this issue.
But I think another practice point along these lines, especially that was emphasized by your point, Ralph Articler, and yours, Ralph Lucy, was that you've got to do two things at the beginning of the case. You have to do a reasonable assessment of what the case is worth. Second of all, when you start talking about discovery, you've got to come up with an e-discovery budget, which is going to limit typically the amount of discovery in the case. So, for example, a $100,000 case, you've got to consider a number of variables, but I think if you talk to most people, they're going to say you're not going to want to spend $50,000 on exchanging documents in a $100,000 case. I doubt most judges are going to order that. You know, you're going to get down in the zone that Kevin was talking about earlier. A $100,000 case, you're going to spend $10,000 on the exchange of documents. You still got to have depositions. You still got to try the case. You still have to do everything else. So once you establish how much you're going to spend on the exchange of information and e-discovery, then it's relatively not simple, but there are parameters you can use to figure out what the cost is going to be. We know typically how much it's going to cost to review documents. We know typically how much it's going to cost in order to do privilege review. These can be charted out almost in a mathematical model. So you can go into the court and say, look, this is a reasonable value. This is how much we want to spend on discovery. This is the amount that's going to cost us to do this particular custodian for this period, this particular custodian for this period, and that's exactly the way we need to confine e-discovery in this case. That's the way we're going to have to litigate going forward in terms of discovery.
If I can tie that back to something that we talked about earlier in terms of the form of production, a lot of us have the habit of drafting requests for production that say any and all documents that show such and such. Anytime you use that phrasing in an e-discovery case or any case that potentially has electronic information in it, which is virtually all of them now, you're giving the opponent the ability to raise an objection and say, if you read that literally, and we talk about any and all information that might show it, once you consider the world of e-discovery and what might be relevant in our computers, you're talking about a ton of information, I'm going to object. So if you're phrasing it that broadly, you're giving the opponent just a very easy objection to make because of what you're really asking when you say any and all. Now, it might be better to talk to your contacts and figure out what you really need on behalf of your client and target that a lot more directly. By the same token, if you're on the other side of that case and you get faced with an any and all type of request, you might want to go talk to them and say, look, I'm going to have to object to that because it's so broad. Why don't we agree on what you're really looking for? Is this what you're looking for? Will you agree to narrow that request to this category of documents? Of course, all lawyers worry about getting taken advantage of and agreeing to that limitation and then finding out it somehow excludes them from what they really need. But I think we as lawyers have a duty to engage in that conversation, and we have to go, if we're worried about getting taken advantage of, talk to our clients, talk to people who are experts who can help us find out, is there a realistic risk that I'm going to get taken advantage of, or is that just my old cranky lawyer bones saying that? And if so, let's see what I get back with that limiting construction. If I'm not happy with it, I can always go back and make a new request. But that type of discovery, cooperation, and collaboration is what will hold down the cost in these cases. Because we're going to do it the old-fashioned way, and you ask for any and all, and I object and say that's way too overbroad and burdensome, and then we have to schedule a hearing 3 months down the road, and the judge eventually tells us, I'm not going to order that, but I am going to order this more limited scope of information. We could probably have avoided a lot of extra dollars getting spent on that case if we had picked up the phone, talked to each other up front, and I said, look, I don't know if you realize this, but here are the implications of any and all. Did you really mean to ask for any and all? Because if so, you're going to get buried with all this stuff if I produce it, or if you're going to make me go defend that objection on a motion to compel, it's going to take you 3 months. Will you agree to use this as a starting point? And then if we need to talk further, let's come back and talk more about that.
And we're going to talk more about how you can manage your case and manage your discovery with and without the judge. But let's go on to one other point with regard to burden, and that is when you send a subpoena under Florida Rule of Civil Procedure 1.410. I see, Kevin, that this rule provides the same conditions or limitations that you provided with regard to parties. Is that correct?
It does, and the idea was obviously to protect third parties because, for example, cell phone providers are getting flooded with requests for people's cell phone records. There are all sorts of things out there that become important to litigation and could have critical information, but when you send out a subpoena to that client, to that non-party, they may have a ton of those they have to deal with. They may be facing a great deal of cost in trying to prepare for these things, to retrieve that information, and to produce it to you. That example of the cell phone companies is critical. They face, thousands and thousands, if not millions of these each year. And they have to have a way to be able to respond and to get some protection from those burdens. And we have adopted essentially the same type of structure where they have the ability to raise an objection that it's not reasonably accessible, or to ask for protection and for help in terms of bearing the costs on that. And the other thing that you might think of as an example there is maybe not the cost being critical in that, because it might be very easy. For example, if you're in a med mal case and you send out a discovery request to the hospital, it might be easy enough for the hospital's IT people to pull those surgical records that you were seeking, or that, the case files for this particular doctor. They could pull those medical records off their system probably pretty easy. It's not really a cost objection you're talking about there. But the hospital probably has an obligation not to produce private identifiable health information about its patients. So before it turns over those records to you, it has to do a lot of redaction, has to make sure that all the patient identifiers are blacked out, and those types of things can be burdensome. This gives that non-party subpoena recipient a way to go back and get protection from those things.
Well, as a judge, there are two things that I can think of, and one is that it provides right in the rule, the court may specify conditions of the discovery, including ordering that some or all of the expenses be paid by the party seeking discovery. So if you're requesting this stuff, you better be careful what you ask for, because you may end up paying for it. The other thing is that third parties are going to have a right to protect themselves from these burdensome things, and they're not even a party to the case. So at least from a judicial standpoint, I'm going to be pretty protective of their need, while allowing your need if you can show good cause for these items. Let's move on to the case management rules of procedure that were amended. You made some changes to Rule 1.200 and 1.201. Now, first of all, we're not going to spend a whole lot of time with Rule 1.201. The reason for that is, I did a course on this for judges, and it's not being used very much.
Yeah, 1.201 is a newer rule that deals with complex litigation, and it's basically analogous to 1.200 in that it provides for the use of case management conferences and for the parties to control how the litigation proceeds. I'd like to back up a step and say this is one of the areas in which the Florida rules are different than the federal rules. Under the federal rules, Federal Rule 26 requires the parties to meet and confer at the outset of discovery and to complete a case management plan that they then send to the judge and get approved, which lays out the basic steps of discovery. In state court procedure, we have never had that sort of meet and confer requirement. And the reason the committee elected not to try to impose that is that there may still be a large volume of cases where we're just not going to have enough ESI for that really to be necessary. And there are certain types of volume cases where you'll never need it, and frankly, the practitioners, even if it was mandated, would not be likely to do it because it just has no value to them. So instead of imposing mandatory meet and confer upon everyone, what the committee did was to recommend that you put in this rule, in 1.200, you have the ability as a party to serve a notice on the opponent, and in that notice, by serving it, you essentially convene a case management conference. It's a little bit different than the standard Rule 26 meet and confer in that it's not just the parties getting together. Now you're talking about the parties getting together in court with the judge participating to talk about certain types of topics in there. They are listed in the rule, and what we added in is an item that says you can discuss with regard to ESI the possibility of obtaining agreements from the parties regarding the extent to which such evidence should be preserved, the form or forms in which such evidence should be produced, and whether discovery of such information should be conducted in phases or limited to particular individuals, time periods, or sources. The idea behind this is that we still want to encourage collaboration and early discussions between counsel as to what really needs to happen in the case in the way of electronic discovery. And because we're not going to force you to do it through a mandatory meet and confer, you need to recognize as a lawyer that if your case is likely to have significant ESI in it, this is your opportunity. And you ought to suggest to the other side that we get together in advance of beginning all the discovery and talk about some of these topics. Talk about who the custodians are. Talk about what we're going to do to preserve and to produce information. One of the things that the committee had to decide whether to address was whether or not to try to discuss preservation. When we talk about preservation, we're usually talking about things that happen pre-litigation, when you go back and you try to decide what information you're going to save, what you're going to make electronic copies of, what you're going to prevent from changing. It's the same thing as not losing the ladder that broke and the person fell off of. You don't want to lose the information that's in your hard drive if it might be relevant to a case that you know is going to be filed. The committee ultimately decided that because that happens pre-litigation, it's not something that we can mandate. We didn't think we had the ability to change the common law rules that prevail in that area with regard to what a person's duties are. And so this is as close as we get. If you think that you need to have some discussions with the opponent about preservation, sit down and talk with them early in the case under 1.200. If the other side says, I really don't want to talk about that, I think this is a waste of time, you have the ability to serve a notice, have that case management conference in front of the judge, and see if the judge will agree with you that it's important to discuss these topics.
Well, this is in your handout 1, page 2, is Florida Rule of Civil Procedure 1.200. It's an interesting thing to me that we're invoking the case management procedure. The thing about ESI is you want to do this early. Right? I mean, if you want to deal with these issues, hopefully cooperating with the other side. If that fails, you want to get it early because ESI will be gone if you don't, right?
Yeah, I totally agree. That's the way the federal rules are set up with 26F, Case Management Conference. One thing that we've seen in the federal system that I think may happen in Florida as well is that in certain cases, I'm talking the larger cases now, in these case management conferences under Rule 1.20, you may find that the judge just doesn't have time to deal with very complicated, and believe me, these preservation issues can be extremely convoluted in large cases, large companies. You may find that the judge doesn't have the expertise. And what I think will happen is maybe what we're seeing in the federal system is that the judge, with the parties' agreement, may appoint a special master and may deal with these technical issues. And I know some state, down in Dade County, there is special masters available, and there's private special masters. So I really think it's important to get these issues resolved up front. There's nothing more expensive than a redo. And there's nothing more expensive than dealing with the fact that, oops, you accidentally destroyed evidence and the consequences that might happen to that. So that's one thing that, although a lot of state court judges may enjoy this, learning about computers and getting into it, some may not. And frankly, some of the parties may not want to just roll the dice, not knowing how their particular state court judge who's assigned to it, how they may rule. I know that's a lot of times the reason that people have chosen to file suit in federal as opposed to state is they thought there was greater reliability and outcome because there were federal magistrates who specialized in discovery and may have some special expertise. Let's face it, our judges have a caseload of 10, sometimes 100 times larger than the federal judges, and I certainly can't blame them if they don't have time to wade into and dedicate 2 or 3 days of their time to address these issues. So I think that's ultimately, in the complex case, something we're likely to see happen in Florida.
Yeah, our judges don't have a magistrate judge to refer it to either. Yeah. Let me put an exclamation point on this judicial question. We have some very, very fine judges in Florida, and I teach in the judicial colleges, as do all of you have done so as well. But there are judges in the business courts that will be familiar with these issues. There are judges that in smaller counties that may never have seen an ESI case when you first come to them. So you need to know your judge. And I think that your first effort should be to try and get the issue resolved. And I always felt that way as a practitioner, but I can tell you as a judge, it's not easy making some of these decisions. And you better, if you ask for something, judge, get involved in my case, you better be prepared for the consequences, because a judge may go farther than you wanted them to go or not far enough. And if you can get an accommodation with the other side, that may be a lot better. In the end result, the judge is going to expect you to confer, and expects you to narrow the issues on case management anyway. So you should talk to the other side and narrow the issues to the ones that the judge may need to decide, and put as little in the hands of the judge as possible for the practical reasons that we're talking about here. But I'm pleased that our rules have gone in this direction, and I'm pleased that we have a way to get into the ESI issues as a matter of case management.
Yeah, Ralph, just one comment or gloss on that. And again, it's kind of interesting. In many cases, what we see is that there's an historical rule that really wasn't utilized very much, or wasn't very prominent. But all of a sudden, because of the shift in ESI and the implications of ESI, it becomes more important. And I think that's the case here under Rule 1.200, because what we have at the top of it in subsection A is that the case management conference can be convened by notice, as Kevin had indicated, notice by a party. You don't need the judge's permission. You can get a status conference by notice to discuss these various topics. And I would recommend that counsel really think about doing this early and often in the case. Clearly, it's got to be negotiated with the other side. But if you find yourself dealing with an opposing counsel that's uncomfortable with this, doesn't feel like doing it, won't allocate the necessary time to get it done and to do it right, filing a notice of a conference with the court, laying out in your motion all the topics that need to be discussed and as many variables as possible, that is a tremendous spur to negotiation. Most counsel don't want to be dragged in front of a court and accused of not cooperating or not really genuinely discussing the issues. So what I find is that this rule can be a tremendous I won't say hammer, but a tremendous force in terms of getting the other side to really participate and focus on the electronic discovery issues early in the case.
We're going to cover one other rule, and in the covering of that rule, we're going to get into that Bray and Gillespie discussion that we're talking about. And this rule is 1.380, failure to make discovery. It's in your handout, pages 20 to 21, but this is the so-called safe harbor provision with regard to sanctions. And you want to tell us a little bit about that? I mean, first of all, you didn't change the sanctions rule in any other way.
No,
okay.
We did not.
So 1.380 is the way it was before, except we've added F, right?
What we added was one section to it.
Or E.
Yeah, and I believe it's E, which is the electronically stored information, sanctions for failure to preserve is the heading. And it's one line. It says, absent exceptional circumstances, a court may not impose sanctions under these rules on a party for failing to provide electronically stored information lost as a result of the routine, good faith operation of electronic information system. This is essentially adopted almost verbatim from Rule 37 of the federal rules, and this is known as the safe harbor. And what it does is to say that if you are simply running your computer system, and under the way your computer system runs, let's assume that there's a certain date at which it normally purges emails or purges documents, and something is lost because of that routine operation of that system, then you can't be punished for that, okay? But the key here is good faith. What does good faith mean? And to understand that, I think you need to understand, first of all, that there's extensive case law under Federal Rule 37 in terms of what the good faith operation of a computer system is. And to look at some examples of that, you might want to look at the committee note. What the committee note says is that the good faith requirement means that a party is not permitted to exploit the routine operation of an information system to thwart discovery obligations by allowing that operation to continue in order to destroy specific stored information that it's required to preserve or produce. So let's say you have that standard, slip and fall case, and the issue is, did the person slip and fall in the convenience store? And representing the convenience store, that there was an internal, security camera that has video of that incident. And you're concerned after, reviewing that particular video that it does show that there was something on the floor that the person clearly slipped in. You can't sit back and say, well, gee, I think that video is going to be gone in another 3 days because I know that every 7th day it wipes out, what happened 7 days earlier. Because if you do that, Once you know that there is an obligation to preserve that evidence, then you may not be operating that system in good faith anymore. You may have an obligation to get in there and actively preserve what's on that video camera and make sure that evidence is not lost. It's a complicated area, and I probably ought to turn it back over to Ralph to discuss the issue of preservation and spoliation.
Yeah, and I'm going to be quick on preservation because this isn't really a rules issue as much as it is a case law issue. The Osmulski versus Oldsmar fine wine case was decided June 29th, 2012, 2nd DCA. It's in your list of citations. The Osmulski case is that video camera case, but in that case, the court decided that it was okay to destroy the videotape evidence, but it's based on the facts of that case, which is that there was no request for the videotape. And I think you have to understand that if you've got a routine system that's going to destroy something, and you have a reason to know that you have an obligation to preserve, we call them a trigger to preserve. In federal court, it's a little different than state court. But if that trigger has occurred, then you are obligated to preserve it. If you don't, it's spoliation. So the question in Osmulski was, did the person who had that videotape have an obligation to preserve it? And the court found that they did not because there was not a request for them to preserve it. And it really is fact-specific to the case, fact-specific to Osmulski, but it gave us some good insight into what the law is in Florida with regard to preservation. Under federal law, if you have a reasonable anticipation that litigation is going to occur, then that's your trigger. Your preservation trigger occurs, even if the case hasn't been filed yet, even if the other side hadn't told you they're going to sue you. The question is there a reasonable anticipation? In Florida, the law up until Osmulski was that unless you have a discovery request, a statute, or a contract requiring you to preserve something, then you don't have a trigger to preserve. Osmulski brings back into play the reasonable anticipation of the preservation. It's an important change. It's a brand new case, and it gives great pause as to whether you should let your client destroy something and the advice that you give to your client. But you're going to have to read that. Unfortunately, that's sort of beyond the scope of what we're discussing here, but we can't ignore it because it's such an important thing, and preservation is such an important thing with regard to electronic discovery.
Ralph, I think what we may see is with Osmulski, plus the committee notes, which go into effect on September 1st, is that there is going to be a change in the rules related to trigger and preservation in Florida. And in fact, most of the cases that we've seen so far don't involve electronically stored information. And my opinion is that it's an open issue now whether a knowing allowance of information to be stored even when you're anticipating litigation as a result of the operation of your computer system, whether that can be the basis for spoliation or not. I think Florida law is ambiguous on that point, and I think it's going to be clarified by this decision plus the comment on this new rule.
Well, the thing about this is Rule 1.380 allows the judge to figure out who's at fault here. Is it the client or the lawyer? And it allows the judge to sanction who's at fault. And there have been cases outside of Florida where the lawyer has been hit for hundreds of thousands of dollars for spoliation. Yes, Ralph.
Well, that might be a good segue into Bray and Gillespie. I see we're on about the 7-minute warning.
Yeah, let's do Bray and Gillespie.
And I'm sure everyone is just dying to hear about it. Anyway, Bray and Gillespie did involve sanctions, and it did not involve the equivalent of State Rule 1.380, which is, it's nice that it ended up being, Kevin, subsection E. That makes it easier for me to remember. It's 37E in the federal. And by the way, in federal, it's considered kind of a safe harbor, not a real safe harbor. So, I think it'll be the same thing in Florida, bottom line to that. Key thing on that is routine and good faith. What is it?
Right?
Good faith and routine. Yeah. If suddenly you have shred day,
Yeah.
Like the Rambus case, that's not routine when you never did it before. Or like U.S. in the Anderson case, when they suddenly said, hint, hint, you might want to follow your retention policies. Don't save anything over 120 days. And nobody did before, and you're sending out that reminder now because you're about to be investigated by, I don't know, Florida Department of some sort. That's not considered routine. So,
But there's an important point to this, okay? Routine, good faith, what are those? They're legal terms, right? I mean, routine may mean something totally different than the client. So it's going to be your obligation as the attorney to put in a litigation hold and explain to the client what the ramifications are of it. Because you're the one who knows what routine and good faith mean, the client doesn't, right? Okay, I'm sorry. My bad.
That's quite all right, Ralph. How could I disagree with Ralph? So anyway, Bray and Gillespie, I think, is a fun case. It's fun because a Florida law firm wins from a big out-of-state law firm and really does an excellent job of lawyering. It wasn't any firm I've ever been involved in, so I can brag about them a little bit. Bray and Gillespie, we've got a handout 5 that has a citation on it. It's a 2009 Middle District case. It involves a hurricane that happened almost exactly 8 years ago in the summer of 2004. Remember, we got hit by not one, not two, but 3 hurricanes, boom, 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 one after the other.
Crisscross.
Yeah, 2 of them, the eye went right over my house, so I'll never forget that. Well, anyway, a hotel claimed that it lost all kinds of damages from the first hurricane. Not a big argument put up by Lexington Insurance Company there on that. Well, then they claimed also significant damages from the second hurricane, and then significant damages from the third hurricane. The insurance company said, "No, wait a minute. How is it that you suffered 3 times?" And the plaintiff here, Bray and Gillespie Management, that owned the hotel, said, "Oh, we were back in operation each time." Those of us who lived through that, including the defense counsel, were a little skeptical, so they initiated discovery and did not pay all 3 claims on the hurricanes. And they wanted to know, what were the records of people checking in. We've all checked into a hotel. They do things on the computer. They record everything. They keep a good record of it. So the insurance company said, well, we want the hotel information, and we want to take a look at your email to substantiate your claim that you were back in business and you lost all this money, even though there were 1, 2, 3 hurricanes hit. And they had, as they were required in the state, in the federal system under 26F, they had a conference. And one of the things that they discussed was, what is the format going to be in the production? They did not give a detailed report, though, when they submitted their report, and they did not have a 16B hearing under the federal system where they're in front of a judge. So in one way, I kind of like the Florida version where you do have a hearing, and maybe there'll be a court reporter, and people will at least have a note of everything that was said. There was no court reporter when the defense and plaintiffs' counsel were meeting, however, in this insurance claim case in Bray and Gillespie. Too bad. And in fact, there was then a production request made. I think the defense probably, when they made the production request, perhaps they would redo that if they were given an opportunity into what the form was. But bottom line is they made a production request. They got produced to them approximately 200,000 computer files. These were produced to them in electronic format. They didn't produce them in paper. They were produced as a TIFF image, as Bill mentioned, with a load file. It included metadata. And here's, however, though, where it started to be a little bit offensive to the counsel that received the production, here the defendant, in that they did not get all of the metadata. They had certain important bits of metadata were stripped out. The most important one, or 2 main ones that really, I think, upset the defense counsel, is the metadata that allowed them to know what email went with what attachment. That was stripped out. This didn't happen accidentally. This is somebody making a conscious decision. Don't let them have that information about what email goes with what attachment. Because it turns out there were about 100,000 attachments and about 100,000 emails. And you couldn't know which email went with what without doing an exhaustive amount of work. In addition to that, they stripped out what's called the index file. Remember the index at the back of the book I ripped out and threw away? Well, they did that on the computer, which means they got dead files. Dead means they could not be searched. They could not try to find, well, which ones had this particular language in it. They couldn't look at these files at all. The defendant protested and said, no, this is not what we asked for. We asked for native, original format production. And the plaintiff said, no, you did not, and they argued about the wording on it. And bottom line is the defendant filed a motion to compel and said that we did not get what we asked for, and we did not get a production in compliance with the rule. The federal rule is 34B2E. That's not important for us to remember, though. The state rule equivalent that we now have, virtually word for word, is State Rule 1.350B. We've been talking about this before. It has to be produced in the form requested, or if it wasn't requested, in the way it's ordinarily maintained or in a reasonably usable form. So in this point, the magistrate judge who was assigned this motion to compel heard the argument of counsel and basically heard and looked at the request to produce and wasn't sure whether it was actually asking for the way it was originally maintained or not, and really didn't understand what was going on, and heard that the plaintiff's counsel say, wait a minute, they didn't bring this up in the 26F at all. In fact, they agreed that we could go ahead and produce it this way. And defense counsel, the Florida firm, said, no, that's not correct. And he had two lawyers, one basically saying somebody's not being completely honest here. And I got to hand it to the magistrate, who then said, wait a minute, I'm going to find out what's going on. We're going to schedule an evidentiary hearing. They didn't like this, this kind of somebody's not telling the truth to the judge. You never misrepresent what happened to the judge. And so she convened two evidentiary hearings, took testimony in the first hearing, and had the lawyers tell what did happen. Had defense counsel say, we specifically discussed all of this. Plaintiff's counsel denied it. As it turns out, the plaintiff's counsel was a replacement plaintiff's counsel. The original plaintiff's counsel that was there had been replaced by new lawyers, so I won't name the firm, you can look it up, from Philadelphia, came down and was defending this. And the judge said, wait a minute, I'm going to convene this hearing, and scheduled another evidentiary hearing, giving time for defense counsel to point out to the prior plaintiff's counsel that they were being pointed to as the empty chair. And in the second hearing, it's interesting, the former plaintiff's counsel voluntarily flies down from Philadelphia to Orlando and testifies. And so this is kind of the backdrop that, too bad there wasn't a court reporter. There wouldn't have been need for all of this, this kind of courtroom drama, wasting, hours of valuable time of the parties. Make a long story short, after the second evidentiary hearing, the attorneys that were making these representations to the court, they were personally sanctioned. The plaintiff was sanctioned, and here's what makes this case important. The plaintiff's law firm was sanctioned. That's right. The plaintiff's law firm itself was imposed a monetary sanction. They wanted to send a message to all the attorneys that came down and were practicing in federal court that you do not make misrepresentations. You do not practice in this manner. And so they not only sanctioned lawyers but a firm, which they have the authority to do it. Anyway, the law firm didn't appeal it. Later, I once gave this presentation and I had one of those lawyers appear from that firm. They said, oh, we weren't sanctioned. I said, really? They said, yeah, well, we paid it so it was lifted. I said, wait a minute, that doesn't count. You were sanctioned. So what did the court find beyond this kind of behavior? It's just spiteful to get rid of this metadata. They found that did not make a decision but indicated, read between the lines that, well, I believe defense counsel, but then said, and here's the important thing that for useful, regardless, even if they didn't ask for it in the original maintained form, that you had a duty to have it be reasonably usable. And when you strip out the metadata telling you what attachment goes with what email, it is not reasonably usable. When you strip out the metadata allowing you to do a search, the index, that is not reasonably usable. So this is an important precedent that we have from the federal. And is, I think, an important ethics message here. This was a wake-up call to law firms everywhere that you need to police your attorneys. You need to make sure they're not playing these kind of dirty tricks in courtroom, and they need to pay attention to metadata, and they need to pay attention to fair and cooperative behavior. Now, you would think that would be the end of the case, would you not, Ralph? But no, this is the Bray and Gillespie saga. I'm going to be real quick on Bray and Gillespie 2 and Bray and Gillespie 3. Bray and Gillespie 2 was, remember those computer records? They wanted it for the experts to give information, and they wanted it in the original program that they entered into at the front desk. And the plaintiff's position was, no, gee, I'm sorry, we don't have that. We've got these paper printouts, though. We got a warehouse here. You know, you're welcome to it. And the defense said, no, we need the original computer records. And they stuck to it. They said that it's called a MS SQL database, that could only be printed out. And here, at this point, you can imagine the magistrate was a little bit fed up. They entered an adverse inference and additional fee sanctions against the defendant for the late and incomplete production of the guest attendance records, and basically rejected the argument being made that the information was not reasonably accessible. If the plaintiff had been arguing using the correct terminology, that would be basically what they were arguing. And at this point, they may not have understood that the original information was the computer files itself, that was the key and important information. And so at this point, they appealed then to the district court. Judge Scriven heard the appellate argument, and at this point, we had third counsel for plaintiffs come in. He was a hero, and he said, okay, guess what? I made a call to the vendor for the software that the hotel was using. And it turns out we can get the information, and we'll be happy to produce it to you now. No harm, no foul. Go ahead and lift these adverse inference instructions. We'd like to produce it. Well, it was the eve of trial at this point. Judge Scriven said, no, it's too late. You've basically proven that your prior predecessor counsel was not operating in a manner that you should have in order to fulfill your duties to the court, and went ahead and did impose sanctions and an adverse inference instruction, did reduce the amount of the inference instruction, I guess, because replacement counsel came in. But it did show that the importance of the team approach. All it took was one phone call of the new counsel, who really, in good faith at this point, he wanted to get the information out there. They got the technical advice, and they were able to produce the file. But at this point, it was too late. And so, there's an ethical moral to this story, as well as a competence moral, and just duty of fairness to opposing counsel is go ahead and try and cooperate with people.
It seems like there's also a way in which you can look at that case, and I don't know the specific facts of Bray and Gillespie. It certainly seems like in that case the plaintiff's counsel knew that these things were being done, and this was not just, well, the client told me that and I believed it. But even if you assume that the case had been like that, which is one in which the client said, I can't do these things, and the lawyer takes it face value, there's going to come a point at which the court just isn't going to listen to that. You're going to have that basic duty of competence that we're talking about. And if the client tells you, oh, this Microsoft database we have can't save anything and we can only print out paper, you're going to have enough sophistication and enough competence to know that that's not likely to be true, that you don't want to go into the courtroom and make that kind of representation to the judge, because the judge may not buy it, especially if the judge has any experience at all with e-discovery. So there is some ethical tension between what are you willing to represent on behalf of your clients, but we all know there have been longstanding obligations under the ethics rules that you can't present false testimony, and you have some duty of competence to recognize what may be false testimony and to not put it on. And that's where I think most of the sanctions in these cases come from, are usually cases where lawyers have made representations to the judge that A, we can't do something, or B, this is all there is, and it turns out that those things are simply not true. And I think that's one of the biggest risks in these cases, is when lawyers go in and try to take the easy path without doing the basic background to figure out whether what they're telling the court is true.
Just by way of wrap-up, I want to thank the panel for all of this input. From a judicial perspective, the judge is not going to want to punish a client if the lawyer's at fault. The judge is not going to want to punish the lawyer if the client's at fault. However, the lawyer has a responsibility, as Kevin said, to make sure that the wool isn't being pulled over the lawyer's eyes as well. I think that we've gone through all of the rules. We've discussed them in detail. I want to thank all of you for your time today, and appreciate what you've done. Thank you.
Thank you, Ralph.
Thank you.
Thanks.